My name is Sanela Zondo, a member of this portfolio committee. I know, Chair, when I'm holding a position, I make it look like it's easy to be in that position, so everyone feels that he can do it, so that's why I'm not surprised, but thank you very much. Thank you very much, Chair.
Yes. Members, we are attending to the sound on virtual. It's a bit low. We've asked technical to help us. But Honorable Zondo was saying, as the deputy chair makes that position look easy. That is why everybody wants to be called the deputy chair. To those who did not hear. Fatima?
Good morning, Chairperson. It's Fatima Ibrahim from Parliamentary Legal Services. Chair, should I proceed just to give a brief overview of our opinion?
I will let you know. We're just allowing people to introduce themselves
So
first.
introduce themselves. All right. Thank you, Chair.
Yes. Jason?
Good morning, Chairperson. It's Jason Felix here from Middle 24 and Network 24.
Who else? Lavan? Lavan Gopal.
Greetings, Chairperson.
Yes. You can go ahead. You have muted yourself again.
Greetings, Chairperson. Greetings, Minister, all the members of the committee, and all present. My name is Lavendran Gopal. I'm a member of the dissolved board. Thank you.
Lucanyo. Okay. I don't know who Lucanyo is. Portia. Yeah.
Good morning, Chairperson and the committee members and the Minister. I am Portia Loilane, a member of the dissolved board. I would have loved to be there, but I've got a very bad flu.
Okay.
Thank you.
Okay, get well. Spokazi.
Good morning, Chair, honorable members, Minister, DG, and colleagues. My name is Spokazi Gana. I'm the ANC caucus researcher. Thank you.
The sound was a bit low, but she said she's the ANC caucus researcher. And Honorable Ngubane, this one, we're not asking them to give us money. You know your problems there. Siputu.
Good morning, Chair, Minister, honorable members, the DG and colleagues. My name is Siputu Mampani from University Education Branch. Thank you.
Spiwa Kumalo.
Good morning, Chair, Minister, DG, honorable members. I'm Spiwa Kumalo, former NSFAS board member. Thanks, Chair.
Mnigeni.
Good morning, Chairperson and colleagues. Minister, Deputy Minister. My name is Mnigeni Pagati in the office of the Deputy Minister. Thank you very much.
Okay. I think we've got everybody. I don't see anybody who have not called. Yes, so as I said, members, we are meeting here to get a briefing from the Minister about the decision he took on the 4th of May to place National Student Financial Aid Scheme under administration. So we will, like I said earlier on, I have asked for a legal advice. So we are going to give to Fatima, Hola, this side. Former board members, if you can just sit here, because when members ask you a question, at least you must not be behind them. If you can just enter here, there's about 4 seats here in the middle. So before I give you, Minister, I'm going to give to Fatima to take us through the legal advice that they've shared with us. Fatima.
Thank you, Chairperson, and good morning to yourself, the Honourable Minister, and all other members and staff present. Chair, I won't be too long. In brief, the legal question was whether Rule 89 of the National Assembly rules, which give effect to the common law principle of sub judice, is applicable to the interaction that's going to be taking place today. For the benefit of those that are not aware, in a Rule 89 provides that no member may reflect upon the merits of any matter on which a judicial decision in a court of law is pending. And sub judice, it's really just a Latin phrase meaning under judicial consideration. And it denotes that a matter that is being considered by a court or judge and restricts public comment then that which may be prejudicial to the administration of justice. So in effect, the effect of Rule 89 is that it was ordinarily understood to amount to a prohibition against members from making reference to any matter before the courts. And the rule, when it was drafted initially, was intended to promote the respect of the judiciary, adherence to the doctrine of separation of powers. But of course, since 1994, we now understand that the Constitution is superior, and therefore any law, any rule has to be interpreted with regard to the Constitution. And Section 42(3) of the Constitution provides that the National Assembly is a national forum for public consideration of issues, and it does this by passing legislation and by scrutinizing and overseeing executive action. So that scrutinizing and overseeing executive action, that is in essence the oversight responsibilities of the committee. It is what the committee intends to do today. There has been some case law, not specifically related to Parliament necessarily in the context of a committee and a meeting as is taking place today, but we do have case law on how to interpret the principle of sub judice. As I mentioned, it's also a common law principle, so it wouldn't just apply in the parliamentary context. And the leading case that we have is a case called Media Television versus the Director of Public Prosecutions. And in that case, it concerned a documentary that was being aired in respect of a criminal case that was still pending before the courts. And there the courts made it clear that you would need to show prejudice, and that prejudice must be demonstrable and substantial. So you can't merely say that because there's a rule, you are exempt from speaking about a matter, the media is exempt from reporting about a matter. So conjecture or speculation on its own that prejudice might occur will not be enough. And in that case, the court then allowed that documentary to be aired. In the parliamentary setting, we had a matter in the Public Protector versus the Speaker of the National Assembly in 2022, where again the court had occasion to consider that sub judice principle, where an argument was made by the Public Protector that the Section 194 inquiry could not be considering her conduct because there were other court processes unfolding at that time. And there the court found that the sub judice rule was not applicable because it would have stifled the ability of the National Assembly to hold the Public Protector to account. And that was also confirmed in another case between the DA versus the Public Protector, where the Constitutional Court then confirmed that earlier decision by the Western Cape High Court. So in short, a rule cannot relieve the committee from its obligation to conduct oversight, because oversight is a constitutional obligation. So the committee must continue its oversight. However, it needs to be done in a matter where you're not going to prejudice the proceedings that are happening in the court space. So there is a way in which the meeting can be managed, where members can certainly ask questions, get clarity from the minister, try to understand what the rationale was for the minister's decision, the process that unfolded, the opportunities given to the board to respond, the practical steps taken, and so on, but to try to refrain from reflecting on the merits of that. So in other words, from reflecting on whether that conduct was permissible or impermissible, if the members would want to make remarks on those sorts of things. I would just ask them to please bear in mind that you don't want to compromise the court proceedings in any way, but in no way should that be interpreted as meaning that you cannot ask the hard questions. Reflections are really your personal attitude towards the matter and your personal views on the matter. And as far as possible, members should try to refrain from airing those and sticking rather to the facts and trying to unpack the procedural aspects of the matter and how it unfolded. Chair, I hope that gives some assistance. It does require the chairperson to closely manage the meeting, and we're obviously available to give further advice as the meeting unfolds. Thank you, Chair.
Well, thank you very much, Fatima. I hope members heard everything, but I hope they heard your last point good, that it will require the chairperson to closely monitor that we don't, I'll give you Honorable Khabo, that we don't, is it better now? No. I think it went off. Yeah. No, that was a good one, DG. There's no comeback. I won't even attempt. Yeah, but I think the voice, the sound is low, ne? There's no sound. Yeah, maybe let's take a 5 minutes break while we allow technical. I'll give you Honorable Khaba. I noted your hand. When we come back, yeah. Appreciate your guidance.
Sound check 1 2 1 2. Testing 1 2
1 2. Yeah.
Sound check 1 2.
Loud, eh? Yeah, because it's not fit.
1 2 1 2. Yeah.
Sound check 1 2 1 2.
Yeah, I'm not. Yeah.
Sound check 1 2.
Let's start, colleagues. Honorable Khabo, check if that mic is working.
Hello, yes.
Yeah. No, thank you very much. We had problems of mics who were not working. So I was saying legal had given us the guideline members so that we know we can ask questions on anything except to determine whether the decision was right or wrong, because that is what is in the court. That is what the legal says. Before the mics went off, Honorable Khabo, you had your hand up. Let's hear.
No, thank you very much, Chairperson. I'm just worried. My request is simple, that we allow the legal advisor probably 5 minutes to make a presentation. I'm worried that during a presentation, we could not capture her, in particular relating to her advice. I only captured the last part where she says that the chairperson must make sure that the meeting is correctly managed. Now, I would not want to rely on that because we've got a rich history on and around the interpretation of the law. So I would not want to fall into that trap. If you would allow us, Chairperson, with all due respect, just 5 minutes. Thank you very much.
So you are requesting, what the last part that you had is the most important part. that that you must allow the guidance of the chair. But on a serious note, you are asking that we ask Fatima to go through. Okay, Fatima.
Thank you, Chairperson. So, in short, the sub judice rule does not prevent members from considering a matter. What it does mean is that you would need to show that there's a demonstrable and substantial risk that a prejudice will occur if the meeting continues. I don't think from the information that we have, and Chair, I must mention that we have not been provided with a copy of the court papers in this matter in terms of the review of that decision of the minister, but it does not appear that in and of its own there would be any substantial risk and prejudice that would occur if the meeting continues. That being said, obviously, members must bear in mind, one, they have a constitutional obligation to ensure that they conduct oversight, and that is first and foremost. But in the manner in which that oversight is conducted, we're just asking that members apply their minds and just be a little bit careful in terms of personal reflections on the state of affairs and what has happened to date. So there's nothing wrong with members asking questions and engaging in the process that was followed, what informed the minister's decision, what sort of information the minister would have had available at the time of making the decision, the responses from the board at the time, if they were given an opportunity to respond, and so on. But rather just to refrain where possible from personal reflections on whether that sufficed or their views on how that process unfolded, if that makes sense, Chair.
Indeed, it makes perfect sense, Fatima. Thank you very much. Minister, we are going to give you to lead your presentation. If you can take us through, Minister.
Thank you very much, Chairperson, for the opportunity to present to the Portfolio Committee and, of course, to the South Africans, the situation at the NSFAS and the stabilization measures that we have introduced on the 4th of May through the appointment of the administrator. The is a presentation that we'll be flighting through, which was presented to the portfolio committee members. I must indicate, I think from the word go, that although there has been a lot of work that has been done by the department in support of and in building up to the decision of the 4th of May, but because ultimately the decision was my decision, I thought that it's prudent that I lead the department's presentation on this matter. The presentation will include an executive summary which frames the decision that I've taken. It also frames the legality of the decision and also the fragility of the institution itself and what I refer to as the cumulative failures, but also our responsibility to stabilization and duty to stabilization of the NSFAS. And then we touch on why the NSFAS as an institution is important, but we also present the background in terms of what has been happening at the NSFAS and our consistent engagement with the institution over time. And in addition, we present the chronology of some of the things that have been happening since I assumed office as Minister of Higher Education. And then we present the legal framework, some of the issues relating to what I refer to in the presentation as the board's defects, which is the substantive board which was appointed on the 20th of February, which I found, the situation which I found when I got into office. And then we also present the legal framework, section 17A to D, looking into the law itself and the status of the board and also what's the best interest and why we've done this, the question of student protection, and then we conclude with what the stabilization plan is and what are the accountability measures and the next step. If you go to the next slide, so when I got into office, chairperson and members, I was confronted with a pile of complaints from especially some organizations within the student movement, but over and above that, was also presented with a legal opinion on the composition of the NSFAS board. The board was appointed in February 2025, and the legal opinion which we sought and received, and over and above that, some of the complaints which included their own legal take on the matter, concluded that the board's composition did not comply with Section 5 of the NSFAS Act. 3 student nominated seats were not filled, but also the finance minister's nominee was not appointed. And one of the provisions which the legal advice emphasized was the criterion which referred to a master's degree, which did not appear in the Act. But also student representatives were added in what the legal opinion referred to as an unlawful co-option process. On the basis of this, as I'll show later, we then had a discussion with the former board around this, and I think I'll speak more around the chronology around those circumstances. But what needs to be said there was that we approached the Pretoria High Court to apply for a self-review, and that application is still pending. Now, the second element is the institutional fragility. There was a comprehensive report that was done by GTEC, which was a rapid diagnostic report which revealed an organization whose operational scale had expanded while institutional resilience had declined. So in 2019, when NSFAS transitioned from a hybrid, meaning grant and loan system, into a purely grant system, we did not reorganize the institution to meet the new expectation. And I think, as honorable members are aware, that there was a process for amendments of the NSFAS Act, which we are seized with as the department and ministry. But that GTAC diagnostic also went further to speak about fragmented manual processes. It spoke about the high vacancy rates within the institution. It noted the poor systems integration, and that basically means that the integration with Home Affairs, with SARS, was almost impossible, which meant that some students who were not qualifying for funding were excluded, but some students who qualified, those who did not qualify in some instances, and I think we'll show some of the numbers, were included, but some who did qualify were not included in the funding of students, and this was because you need SARS data to be able to determine whether someone meets the 350,000 threshold. And so, this has proved, and that's why you've had, in some instances, I think it gave rise to the concept of defunding of students, because later on, through various forms of verification, the NSFAS then established that some students who qualified did not, qualify. But included over and above the poor systems integration was the decommissioning of Phoenix, which was a legitimate act, but which completely decapacitated NSFAS capacity to collect, loans, but also to administer loans. I think in 2024, former Minister Nzimande announced a 3.2 billion rands worth of funds whose intention was to intervene with regards to the missing middle. So the incapacity of the NSFAS, and I think we've seen the numbers, were only just about, I think, not more than 2,000 students, were granted loans. And even in those instances, those loans were granted through the institution as opposed to an NSFAS-led process. And then Orion, which is the system that NSFAS was using, was functioning without a calculator, which meant that it basically compromised the systems in terms of whether students do qualify, or not, and also a determination, of the eligibility and so on and so forth. And then there was a 46 billion historical loan book, and I need to explain this because immediately after the introduction of the fee-free higher education in 2019, in many instances when NSFAS, I think from there on, when NSFAS would almost on a yearly basis come back to, to the department and to Treasury to get more money, some of the resources which we used to close the gap were resources which were the resultant of the repayment of loans, historical loans. So there were also issues around the historical loan book, which I had consistently raised with, both the board and the administration, and that 46 billion is likely to be, as per the AG, impaired. And what this means is that even though we know who owes the NSFAS and all of that, we're likely to lose, that money. So the recommendations essentially from GTAC was that we need to stabilize the institution, we need to modernize, and then reform. And this for me were quite worrying factors. And I remember in one of the meetings which we had, quite a long meeting which we had with the executives, around the outcomes of that meeting and some of the actions that needed to be taken. Then there is the AGSA's disclaimer audit, of the 2024-2025 financial year, and which identified 9 material irregularities, and what this means, I mean, the disclaimer audit essentially means that the AG says, look, we can't even look at these books. And I know that the NSFAS, the former NSFAS board had indicated to me that this didn't happen in their period, in a period wherein they served as the board. But they were appointed in February 2024, 2 months before the conclusion of that financial year. 2025, yes, 2 months before the conclusion of that financial period. But also, they also had responsibility to act on those material irregularities, even if they didn't happen. But I also think, I mean, imagine, Honorable Msezana, if our president, when asked certain difficult questions around why we don't have houses and all of that, and then they say, no, that's because of the former president, Jacob Zuma. Because we have to take responsibility. So it's a continuum, as an institution, as a board, or as a person who holds office. It's a going concern or something like that. And yes, there may have been those issues, but I think the board itself had a role to play in ensuring that we correct those those material irregularities. In fact, the reports that I have been receiving through the department and contained in the board's own report was that for instance, forensic has not been working for the whole year. Which was essentially their response. When we had a meeting with the AG, together with the chair and the executive of the board, sometime I think in March, and when we pressed around what is the plan, has anything been done to ensure that we address those material irregularities? Nothing came much out of that, and that's why. Subsequent to that meeting, I issued, the board with a set of directives that they had to attend to with specific deadline. But also, the AG found that there were issues around data analytics, which were also identified by GTEC. And as I said, so what the AG established was that when they triangulated information with various other data sources. They then established that, for instance, there were 822 deceased students who were funded, and about 14,169 students who, were above the income threshold, and then there were also issues of unresolved appeals. Then cybersecurity breach, which I also, raised with the executives and the board chairperson. Now, we had a responsibility, I think, given all of these things, meaning the question of the composition of the board itself, which I had already indicated that I'd approached the court for self-review, the GTEC recommendations, which suggested that we need to stabilize the NSFAS, then modernize it, and then introduce some reforms. And then those cumulative failures, I think I need to also emphasize that beyond the AGSA's issues, there were also successive board resignations. I think a week after I've gotten into office, the deputy chairperson of the board resigned. Following that, the chairperson, together with 3 other members, and then in May. So in a period of 6 months, we had the substantive deputy chairperson, Sibia, the substantive chairperson, Standa, resigning. We also had other 5 members of the board, including the person I'd appointed as an interim chairperson subsequent to the resignation of Dr. Standa. then essentially the functioning of the board, in my view, was not in a way that I believe would give us the stabilization of the of the NSFAS. So the stabilization then had to depend on administration under Section 17A, which was a statutory response to protect students and also public funds. I think we will know that we're concluding the financial year. Some reports and statements had to be submitted, for audit and so on and so forth. So this is a very fragile period, which could have inadvertently, in my view, affected the proper functioning of the National Student Financial Aid Scheme. I avoided, I acted in order to avoid unlawful institutional drift and also to ensure that no students' prospects are prejudiced by governance challenges or any form of financial or administrative paralysis. So the law provides that I can make that intervention in terms of Section 17A 2D of the NSFAS Act, which I believe is a mechanism that this Parliament has created if the executive authority feels that this needs to be done. And I must indicate that this was not a political fight with the board, but it was a legal governance intervention which was intended to protect the NSFAS and students. Now, we know the constitutional mandate, the right to further education, which the state must make progressively available and accessible through reasonable measures. And I think the country out there, NSFAS touches almost every second household in the country. So when there are things reported in the media, particularly the poor and working class students, most of the historically disadvantaged institutions have a significant proportion of their students being funded by NSFAS. And so when there are these type of issues that are reported in the media around the challenges that they can persistently have or are persistently in the NSFAS. So it raises some concerns as to will we have this institution surviving. In fact, although I had said when I assumed office that I'm not a minister for the NSFAS, I strongly believe that stabilization of the NSFAS as an institution will help us stabilize the sector as a whole, because it affects 800,000 or so students, has funded so many of those students. It disburses in or around 50 billion rands, and with a loan book of 98% about to be impaired or have been impaired. So the NSFAS is important, and I think the concern is justified, and I think it's our responsibility beyond personalities, beyond political influence or political interest. I think it's important that we all get mobilized towards the stabilization of the NSFAS. The things that have been happening over the years, where we had successive administrations, where we also had successive boards, require us to soberly reflect on its state and also indicate what is it that needs to be done. Now, those are some of the numbers as it relates to the audit and governance findings by the AG, the 9 material irregularities, the question of the deceased students and the AGSA data analytics, but also those 14,000 students who were found to be above the threshold by matching data with the UIF and so on and so forth. And then I think an emphasis on the question of the disclaimer itself, and so these are the interconnected challenges that I believe the NSFAS faced. Now, there is, so there's a suggestion that, I think made everywhere, that I woke up one morning on the 4th of May and decided that I'm going to appoint an administrator. But there were things that, there were activities that happened before the date of the, of the 4th of May. And, and those things, include not just the composition of the board, but they also include interactions with the board. Immediately after the then chairperson, substantive chairperson, Dr. Stander, resigned, I convened the board, and by the way, there were concerns that were raised, and I think the portfolio committee itself had invited Dr. Stander to come and appear. But some of the issues that were raised, which I also presented before the board to respond to, that Dr. Stander had raised, also raised some concern, which led to heightened oversight. So even after I had appointed an interim chairperson, there were also a series of meetings. I looked at the number of times that I had an engagement with either the NSFAS board or the executive management of the board since I was appointed, more than 20 times, when we met to discuss either this or that issue relating to the board. The board itself in the financial year met 28 times. So this was, the board's meeting of the NSFAS since they were appointed in February 20, met 28 times. And so, there was a time where we had to heighten oversight over the NSFAS, engaging them, probing them, but also, supporting them, going with them to engage with Treasury around the 13.5 billion rand, despite some of the challenges which were glaring, which I had also raised with them, in writing, issues around data integrity, concerns by Treasury, and so on and so forth. But all of those discussions yielded, results. But the point which I'm trying to emphasize is that the engagements and interventions, with the NSFAS and the NSFAS board, were quite consistent and heightened oversight. And one of the points which has been raised has been the fact that I think when we appeared, DG, here in Parliament earlier in the year, when we're giving the report on the NSFAS, we said that, in terms of tuition, in terms of allowances, and so on and so forth, that, comparatively speaking, the NSFAS has done very well, Honorable Cezanne, and I think you've also mentioned the point during our debate in Parliament. Now, of course, the board played a role, but it wasn't exclusively the role of the board, and in fact, it had to do with the operations in the board. In December, when I probed around readiness for the academic year 2026, I realized that we will need to give more support to the administration. And that's why, one of the last letters I wrote to the NSFAS was sometime in December, because we're seized with preparing for the academic year 2026, with a response sometime in January, but from late January into and until the end of the academic year, I met with the NSFAS at least a minimum of once a week, sometimes twice, sometimes thrice, and we had, a war room that we'd established in order to deal with, some of the challenges. And I must say that the administrators at the NSFAS and the workers, the staff at the NSFAS, for having participated in that war room, was a huge contribution. But we had to provide them with the support, because I personally was quite worried, and I think we need to commend them for that work. But we then show there, cumulatively and progressively, how the situation basically escalated, to the 4th of May. And what I also want to, I think, flag there is the fact that in March, as I said, issued directives to the NSFAS board to act on that based on the issues raised by the AGSA. But I also, because one of the major concerns raised by GTEC, concerns raised by the AG, and so on and so forth, was the issue around the vacancies, especially at a senior level. And so that's why I think in between then, instructed the board to ensure that by the 31st of May, and this was when they were asking me to do a further extension of the acting CEO's contract. So when they asked me for that, I indicated that I'll only extend the contract for up to the 31st of May, and that this will be the last extension that we make, and that they should ensure that they appoint the CEO, a substantive CEO, by the 31st of May. And sometime in April, the interim chairperson indicated to me that he was quite concerned that some of the board members want to go ahead with the appointment of the CEO without having concluded the processes building up to the reports that the board need to consider. And on the basis of that, I agreed, but also some of the board members themselves were asking our stakeholder person in my office that they would like to meet with me. And on the basis of that, we had a meeting I convened a meeting with the board on the 13th of April. And in that meeting, I asked them for a report in terms of the process towards the appointment of the CEO, as the interim chairperson had indicated some concerns. And based on the report that they presented to me, I then indicated to them that that they shouldn't rush the process and conclude the process without having followed all the the processes internally, and that I had actually given them the deadline, and that there is no pressure. In my view, there was sufficient time to meet the deadline that I'd imposed on them, and so they shouldn't, they need not rush the process and even jump some of the some of the processes that they are required, which included, I think, the finalization of the report in their Human Resource Development Committee. Then, subsequent to that, I then received resignations from the interim chairperson and the deputy chairperson. I'll talk a bit about that, and I think I've already emphasized some of the points earlier on this. And then on the 4th of May, after having consulted with the members of the board and listened to their views, I then took a decision to appoint an administrator. So where are we now? There are two matters, one in the Pretoria High Court, which is looking at the self-review hearing, which is, I think, now already scheduled, and then the other in the, I think, Gauteng High Court Division, I'm not sure the name of the court, where the former board members are challenging my decision to appoint an administrator and therefore, dissolve the board. I've already spoken a bit around the, the legal framework, but just to emphasize that at the time the board was dissolved, there were only 7 members of the 18 that are required by the Act, and I think it was also worrying that a chairperson was substantively appointed, a deputy chairperson who was substantively appointed, and also an interim chairperson whom I appointed had resigned in a short space of time. This is in about 6 months, and not only the 3 of them, 4 other members had also resigned, and I think this was quite concerning for me that we are having this situation. So it's not just ordinary members, not just only ordinary members, but we also didn't have a Minister of Finance. And maybe as a point of emphasis, Chairperson, even with the directives that I had given to to the board itself, the board in its composition should include specific expertise, and I think in this regard, financial expertise is one of the most important element. And I think there was a letter which the interim chairperson of the board wrote to me in February, asking that I fill in the vacancies. But I could not do that because I'd already approached the court for self-review of that decision. So it would have meant that I'm extending an irregularity of the board, and in any way that process itself would have required a fresher process of nomination. And I think some would ask as to why did we not immediately dissolve the board when we got the legal advice in October. The points which I made at the time in November, I think, the points which I made at the time, on legal advice when I met with the board, was that at the time, it would have been, in my view, and having just assumed office, it would have been, in my view, a bit disruptive to dissolve the board, but we're also dependent on what is referred to as the eau de Kral principle, which means that an unlawful administrative act cannot simply be treated as a nullity by executive preference. So I wouldn't just prefer the board itself to be nullified, and that board remained capable of producing legal consequences until properly set aside by a court of law. So my reliance was on the court of law itself. And of course, when I met with the board in November to have a discussion on this, the understanding that I was given leaving that meeting was that the facts are common, in terms of the process with regards to the appointment of the board, and that we should endeavor to conclude the self-review process as speedily as possible. And I hope that those 2 cases are treated differently. So those are some of the points in terms of why we believed and had approached the court on the defects of the board. Now, with regards to administration, the statutory mechanism provides 3 alternative routes to administration. And I must emphasize, Chairperson and members, that the section is disjunctive, meaning that is disjunctive, meaning that it's alternative, and that it's not necessarily conjunctive. And I'll speak a bit, about this. But what it essentially means is that any one route is sufficient, of the routes that are available towards the committee. The route A, which was the audit or committee report, an audit of financial records with regards to that part, which is, we believe that it was squarely met given the AGSA's disclaimer. And then the second route, which is any other circumstance, I believe that the board itself, with successive resignation, has led to governance collapse. And then, of course, the board requests such an appointment of an administrator. The board did not request the appointment of an administrator. They did when I wrote to them and asked them to tell me what we should do now. They did say to me that there are various alternatives which I then considered safe of administration. And so what are the automatic effects of that decision? It means that the board is dissolved from the date of the administrator's appointment, and that there is no separate dissolution decision. It is automatic, it is statutory, and that it should be regarded as such. And also that it was done in the best interest, because this, as the law requires, that I may only act if the appointment is in the interest of the NSFAS and of higher education in an open and democratic society. And I believe that I had acted in that regard. So as we stand today, and as I said, of the statutory requirement of 18 members, 12 of those appointed substantively, one appointed, co-opted by the board through the the then minister's intervention, and another one co-opted by the board. Of all of those, only 7 board members were remaining after the resignations. Now, with regards to continuity, I need to then say, Chairperson, here that the person that I appointed as administrator is Professor Matebula, who is currently who was at the time the head of the Tshwane University of Technology Business School, and who was also the chairperson of the MDDA, appointed by the president, but has also served in various boards, in the last 7 to 10 years. I know that issues that, there has been some issues raised with regards to, Prof. Matebula's, competence and whether he's of a sound mind and all of that. I think that based on his qualifications, but also based on his experience, I believe that he is the right person to help us stabilize, to work in stabilizing the the NSFAS as an institution. Now, continuity measures, it's important to emphasize that disbursements continue. Student funding are operating without any interruption. The schedules are being met. The staff at the NSFAS continue to work to perform their professional responsibilities under the administration. But also, I think, as honorable members are aware, the administrator himself, together with the NSFAS executives, came to to the Parliamentary Portfolio Committee. Also measures have been taken to protect student accommodation, students being potentially being evicted and so on. But also that I must say that the administration is not a permanent intervention. It's a temporary intervention that the law provides for. So we've also made it expressly clear that there is a potential for earlier termination upon the appointment of the board if we believe that the administrator has been able to meet the requirements, the stabilization measures at the NSFAS. and that the maximum required is 24 months and extended. But the practical aim is to have the shortest time possible for this administration. In the broader sense, we want I expect the administrator to, look at, issues around student accommodation. There has been some, challenges there. Issues around ICT. I think the board had, for some time, I think there was a deadline of September where the board had to meet the deadline for the approval of an ICT strategy. That hasn't been done. Put in place, risk policies and measures which haven't been there, which is something that the AG has flagged. But also deal with what the GTEC recommendation said, which is stabilize, modernize, and then reform. So we're quite, looking forward into dealing with all of this. And then there are also legal issues, policy issues, but at the center of it, working together with the department, help us drive a sustainable student funding model. And then there are all of those things. But I think what's important for now is that there hasn't been any disruptions. There has been some concerns, one or two here and there, that were raised around, the protection of the students who are expecting allowances and so on. I think NMU is one of those institutions, a couple of those. And these are not the result of, the administration. And I think the NSFAS has been able to respond to, some of those issues. In terms of stabilization, as I said, operational continuity, but it's also important that we have consequence management, meaning that, we have to have people responsible for certain actions, and then deal with, issues around appeals, deal with, the TVET college closeout report, and I think one or two other universities, deal with audit remediation, the remedial action plan from the AGs, but also deal with issues around data analytics, our integration with SARS, and our integration with Home Affairs. What this means is, one, those who are able to repay their loans, this thing of data integration, those who are able to repay their loans would then be able to do so, which means we have a bit more money in the kitty to to cover any potential shortfalls, and therefore an investment into the country. But it also means that we will not fund people who do not qualify based on the existing criteria. It also means that we will not fund, dead or ghost students. So the question of systems integration, and it's not only just with SARS and Home Affairs. It's also with institutions, TVETs, universities, and so on and so forth. And then the ICT digitalization, to accelerate the approval and implementation of that strategy. We're expecting quarterly reports with and through the DG to the minister, but we're also expecting that they will look internally, of course, first for existing capacity, and where there is a need, source external, capacity. We're expecting an initial stabilization plan to be submitted, and hopefully at the next available time that the committee has. So where to? I think we, are looking at the in the immediate. There's a court hearing, as I said, on the 2nd of June, and I must emphasize that I will respect the court's order, whatever it is, and also there is the self-review hearing, which we expect that would happen by the 31 July, and I think some people will ask, why did we not wait for that? So that process itself, has been lying dormant until we then appointed the administrator. So it's now active because we've received the response from the board, from the former board members, or heads of argument, or it's the court language is a bit, So there's that process, and then there's also, first quarterly reports that we'll be expecting, and also a stabilization plan, PFMA submissions to also be done. The administrator has also already started engaging with stakeholders, meeting with the AG, the SIU, meeting with student bodies, with university vice chancellors, with some in the TVETs. So some of those engagements with the stakeholders is happening. In the long term and targeting 2027, a sustainable student funding model, but also systems in place for the missing middle. This announcement we've made in 2024, and I think it has to be one of the priorities for the administrator. And then the loan book recovery, we still believe that should also be done. And then TVET equity. I was listening, Honorable Chairperson, to Honorable Lonzi, who was waxing lyrical a few days ago about funding TVETs for free. And in fact, this, we agree with you. We considered that, and I think if you look at the HEHA report, it actually expressly had instructed us to do that, and I think it's. I think so. Yeah, of course. No. I mean, we fully agree with that, and I must say that it's one of the things which we also considered for this financial year, but because of systems challenges and so on, we had to put it on the side. But we think it's a priority. Equity with between TVET college students and university students, and I think in a much more progressive but accelerated way. And then reconstitution of the board. So as I said, administration is not permanent. And then transition to governance, from administration to ordinary governance. I know we hold a lot of views about what ultimately should happen to the NSFAS. The chair mentioned the deputy minister's speech at the budget vote. NSFAS should shut down. There has also been some discussions. I think the commander-in-chief of the EFF also said something similar. We should just send the money to to universities, and all of that. And what we've said, Chairperson, is that in our discussion, so when we agree on what a sustainable funding model for the NSFAS is, what we also need to then agree is, okay, so this is how we're going to sustainably fund students. What model or mechanism is required? And I think it's fortunate that this discussion is also happening as we're looking at the NSFAS Act. And then, so as I said, then transition to governance, whatever it transitions into, and then a full implementation of the ICT digitalization. I believe that our country has the necessary and available resources and capacity, both within the state and outside of the state, to have proper digital system operating in the NSFAS. We cannot have a situation where in 50+ billion rand is managed on spreadsheets, on Excel, and so on and so forth. So this should be the standard we believe we should be measured in. This body exists for the more than 800,000 students who in 2026 alone depend on tuition, accommodation, food, and the daily means to study. And if we fail to do this, then we would have failed, those number of students. And this is the standard which we believe any decision about the NSFAS must be measured against. Thank you very much, Chairperson.
No, thank you very much, Minister. So, members, I'm going to note you. I've done a list here for you guys. No need to raise your hands. You know the rules. You direct your question either to the minister or former board members, and they will respond. So your participation, board members, will be in answering questions, and I will take into account members' time when you respond, because you did not do a presentation. So we'll take that into consideration. So we're 12 members, we're many. So we'll give you 15 minutes each. We will take into consideration when the board members answer that they might want to say more, and I'll take that into consideration on your time. Let's not forget the advice from from legal about expressing our views. Let's just establish the facts, and then we'll take it from there. So my list, members, I'll start with you, Musezane. I'll come with you, Lonzi. Then I'll go to you, Khabo. Then I'll give you Ndatengubane. Then I'll come to you, Low. Then I'll give Dr. Christians. Then I will give. Then I'll give Yanga, Governor. I will give Honorable Khachau. I will give Honorable Souls. I will give Honorable Zondo online and Honorable Manamela online. So that will be the format. So Honorable Musezana, I'm trying to start my watch, my clock at 15 minutes and 0 seconds. I would advise that members, you also open your own, because when your time ends, you think my watch ran fast. So I want you to do the same. Sorry, so that we're on the same page. Honorable Musezana.
No, I'm going to ask Advocate. Advocate Kuta for now. Just one question, then Chair, probably you'll pause my time until the minister comes back. Maybe just on the.
Let's do this. Let's wait for the minister.
Okay.
We had agreed on 15 minutes. I heard Honorable Khachau, you're asking about the time. It's 15. Oh, and I did say that I'll take into consideration when you ask the board members, because they did not do a presentation. I agree, you know your numbers. So it's Honorable Musezana.
Can I ask a question?
Yes, what's wrong? Joyful?
No. Sorry, Chair. I will switch on my camera, just not now. I just wanted to ask, in light of what you just said now, so that I'm clarified. So the status of the former board members in the meeting is that where we want to ask them a question, we can ask them a question. Is that what you... Because I just want to get that clarity here.
Yes.
Okay, Chair.
Thank you. So the numbers are Honorable Cesar, Honorable Lonzi, Honorable Khabo, Honorable Ngubani, Honorable Low, Honorable Christians, Honorable Governor, Honorable Khachau, Honorable Souls, Honorable Zondo, and Honorable Maimel. So that is the how we're going to. Honorable Cesar, let's start.
No, thank you very much, Chair. Thank you, Minister, for the presentation, Baba. Maybe where I'm going to start, because the time is very limited, Minister. I don't know why. Minister, let me start here. There are two previous administrators at NSFAS before the board that you just dissolved now. There was Mr. Randall Corolesen and Mr. Sitembiso Freeman Nomvalo. The last administrator, Mr. Nomvalo, left the institution without providing a closeout report. That is as far as we know as things stand. We also are aware that he earned a very fat salary there, but did not produce a closeout report. It is also alleged that currently Mr. Nomvalo is now an advisor to one of your other administrators in the SITAs, which is something probably that you might want to confirm. Why is it that do you believe now that an administrator will stabilize the entity when two previous administrators of the very same department have failed dismally to do so?
Okay.
If you could just firstly confirm if what I'm saying is true, that we do not have a closeout report of the former administrator. In fact, even the audit opinion you are speaking about, the disclaimer, is attributed to that very same administrator in the 2024-2025 audit outcome. And that now he's still in the department as an advisor to one of your other administrators in the SITAs. Then you can comment if you think that now an administrator will do the work that the other two have failed.
Okay, all right. Thank you, Honourable Cesar. The first administration was appointed during some instability within NSFAS, and you want me to confirm? Well, I don't have the closeout report. Then Minister also didn't have the closeout report from the then administrator of the NSFAS. But I'll if I may talk to that just now, which is part of, I think, responding to the overall question that you're asking. And that administration, which took place, Randall Carlson, from 2019 to 2020, was basically to stabilize the student-centered model. I think that's when...
Sorry, Minister, could you just not get into the detail? But fundamentally, you said that NSFAS is fragmented, therefore it requires stability through administration. So I was just highlighting that the two have failed to do that, because if they had not failed, you would have not have taken the decision now to put them under administration again. Then I mentioned in particular Mr. Nomvalo Freeman, because he did not submit a closeout report, which means that he was hired and paid, and you do not know what work he did there, because he has a disclaimer. This disclaimer that you are very sound about is attributed to his administration.
Okay, so your question is it's three parts, and if I may respond to it, I mean, you are fundamentally asking me what is going to be the difference with this administration. Yes. Now, so firstly, administration comes in, when whoever is the executive authority believes that there is a need for such an intervention, meaning that the board that exists at the time, and I think Parliament foresaw this when they included the administration clause in the thing. So when a board is unable to, oversee a stabilized institution, so it's not just the administration itself, but it's also the substantive boards. So cumulatively we'd had, since 2019, we had a board that was dissolved, an administration up to 21, and then a board that was put in place, which was then also dissolved. And I think, the issues are, popular. And then Nomvalo was then appointed for a period of 2 years. Of that period, when I came into office, I was made to understand that, there was a dispute between the department and Mr. Nomvalo around the legality of his termination and issues around payments, an issue which is separate, which, I wouldn't want to, explore its details as is now. But yes, I think it's confirmed. I'm aware of the fact that he is working in one of the institutions as an advisor to the administrator at the construction SETA.
No, thanks, Minister. I think if I had more time, I'd spend some time there, but because I have many other questions, maybe I'll come back if I still get time. Advocate Kuta, am I saying it right? Yeah. So, can we speak about the legality matter here? The Minister wrote a letter to the board in January indicating that because the matter is before the court, he's precluded from taking administrative action on the board now. So I just want to understand, legally, is the Minister correct to dissolve a board when it's before the court on self-review or whatever application that is there in the court currently?
Thank you. Can you hear me? Thank you so much for your question, Mr. Msezan. The question that you are asking is tricky in that the self-review application is different from the administration process. These are two separate legal processes. The self-review process is a process that is initiated by the minister himself. He is taking himself to court to say, can the court make a pronouncement on the appointment of the board? And the second one, which is the administration, is a process that is under another section of the Act, which is 17A, and it is preceded by other processes, which include the directive that Minister sent on the 26th of March as per Section 4A of the NSFAS Act. So these are two separate processes.
Was the self-review not opposed by the board?
I don't know what you mean by opposed, because if you look at their papers, they do not oppose. They almost agree with everything that is in the minister's affidavit, except one area where they say they should still be kept as a board because they are able to do good work if they are given an opportunity. Thank you.
Thanks, Advocate. I'm not sure which board member might assist us. The Minister in his presentation asserted that after having presented the audit outcome of 2024-2025 that is attributed to the former administrator, that nothing was done by the board. I'm going to just, get a sense of understanding from that. what have you done after you had learned that there's this audit outcome presented to you by the minister?
Thank you very much, Honorable Msezane. My name again is Sianda Mngadi. I think it is not true that we have not done anything. So, for example, when the minister issued a directive, we responded comprehensively with a list of a document. For example, we submitted an audit improvement plan. We submitted consequence management plan. We also approved a digital transformation strategy, which we were going to form part of the annual reports that is due recently. We passed a lot of policies in terms of data security, and we were reintegrated back to SARS under this very short period of this board. And we submitted a comprehensive closeout reports. We submitted also a report on monitoring and evaluation of NSFAS accredited student accommodation. We also submitted 2026 application cycle comprehensive appeals reports to the minister. We submitted a board position on the sustainable funding model. All this on the 30th of April, which was in line with the directive of the minister. And the minister, by the way, has never responded to those submissions.
Yeah, no, thank you very much. Minister, could you respond to that, please? Because you did indicate in your presentation, I was listening to you, that the board, you did indicate that you gave him a directive, but you said nothing had been met in that directive. And you had given them deadlines, which you did not say the dates, except the 31st of May, that you said they should have appointed a CEO at the time. Then you mentioned that they were, or you were suggesting that they were rushing their processes, and there were other committees such as the HR committee that had not done their work and presented the board with a report. In fact, maybe before you get in, the HR committee that the minister refers to, that should have done work before it came to the board in as far as the CEO's appointment is concerned, was there a report that was already presented to the board to consider regarding the appointment of the CEO, asking to the board?
Honorable Msezane, may you please clarify that?
The minister indicated that there is prior committees built up to the appointment of the CEO by the board. So I'm asking if there was a report that was presented to yourselves by the HR committee to consider, or the work that should be done first, which probably is interviews, shortlisting, whatever is done by the other committee, was it presented to the board for consideration for the appointment of the CEO?
Dr. Maputa will take that on.
Thank you, Honorable Member. Yes, so prior to the board considering the appointment of the CEO, the HR Audit Committee said, and after deliberations, they recommended a candidate. So that was after the deliberations and the work, the process of the panel concluded. So it was presented to the HR Audit Committee. The HR Audit Committee deliberated and then recommended to the board. Thank you.
Thank you very much. So, Minister, the board has at least given us a picture of what is different from what you presented, because you indicated that looking holistically at the work that was being done by the board, you resolved to seeing administration as the resolution to their problems. They've presented what you have not touched on, the work that they would have done. I want you to respond to what the board is saying in terms of that, but also do tell me what you meant when you said they were rushing the process and there would have been work that should have been done by other committees that was not done regarding the appointment of the CEO, because they indicate that all due processes were done, build up to them, then dealing with the process of the appointment of the CEO.
Yeah. Well, thank you very much. I think firstly we must note that the report that is being referred to was sent to me on the on the 30th of April, which was the report which was sent as a result of me having asked the board members as to, what are we going to do? We have people having resigned, and so on and so forth. But secondly, what I referred to was that there's an AG's report, not my report. There's an AG's report with, with materiality, and which the board had the responsibility to act on. And subsequent to that AG, which they haven't, by March this year, 2026, which referred to the 2024-2025 audit report. So what I'm referring to when I say no action had been taken by the board, I'm referring to the AG's own, which then resulted in me, issuing the directive to the board on the 27th of March. And even then, so if we want to get into that report which they gave me on the 30th of March, we can, which at that point, my discussion with the board was, what do we do? You've got all these resignations, what do we do? But if we look into that report which they say they gave to, which the honorable, the former board member is saying, Mr. Mgadi is saying they gave to me, it was process. It was basically reports, around what is going to be done. It was, how we're going to have strategies. For instance, the ICT strategy that they are referring to, they were supposed to have adopted, the board was supposed to have approved it in September 2025. So 7-8 months later, that had not been done until such time that I issued the directive. But I think importantly, Honorable Msezana, what I want to indicate is that the very same report had indicated, for instance, that supply chain management had not been working. They'd indicated that EXCO had not been functional. Financial committees had not been functional. So even if I considered that report, which they gave me on the 30th of April, together with their quarterly report and their business plan as a board, I do not think that it satisfied me enough in order not to proceed with administration. Thank you.
No, thank you very much. This AG report, when was it released? The 24-25 AG's report.
I'll have to check the actual date.
It was discussed with us before being released.
Yeah. So we yes, we had a discussion with the AG in March. I think we're on the 20th, I think a day or after we issued the directive to the. So we had sight of it as part of our discussion with the AG, I think on the 26th or 27th of March.
This year?
This year, yes.
Okay.
And I think a few days before, or a few weeks before, the NSFAS together with the department had appeared before Parliament on some of those elements of that report.
Yeah. The reason I'm asking
I just
is,
need to, yeah.
In your response, you're saying they had not done anything on the material irregularities of this 24-25 financial year. But if it's released in March, and then in April we then say they've not done anything, I think it might be a bit unfair if that is the case, unless the material irregularities you're talking about a different financial year.
Yeah, we'll have to check that, Chair. But I think importantly, what I also need to emphasize is the fact that, the board as it stood on the 27th of April, when the interim chairperson and and deputy chairperson, and chair of the HR committee resigned. I had no view that the board, as it was constituted at that point, was properly functioning to the extent that they would have been able to deal with all of those issues. And I think an emphasis should be to the fact that the expertise that the board itself required had already been depleted. Yeah.
No, thank you very much. Honorable Lonzi?
No, thank you very much, Chair. I don't even think I'll be long. So there's almost a public suggestion here, Minister, that at the center of the dissolution of the NSFAS board is your wanting to somehow have some interfere in the appointment of the NSFAS CEO. And it wouldn't be the first time we see that. I think over the years, many ministers have shown us, and the courts of South Africa have actually proven many members of parliament to be correct when the executive is overstepping in matters that the Act would squarely place on the fiduciary responsibilities of boards. So whether it's the dissolution of boards to place them under administration so that a minister can gain total control over the entity, whether it's trying to influence the CEO to put in either comrades or friends or whatever, or anything of that sort. So I want to deal with the meeting of 13 April, because I did also send that letter early in the year, if you remember. Now, my first, maybe let me start as questions so that we can have a proper lay of the land of what that meeting looks like. The first question I'll ask to you, Minister, is, was there a formal meeting invite for that meeting?
Yes, the board members were called by my community license officer in my office to indicate to them that I would like to meet with them.
By formal, I mean, was it sent on WhatsApp? Did you call by phone call?
By
or
phone
did you
call.
send?
By phone call.
So there's no letter that the...
No, just don't go to WhatsApp again. You're going to say I've
I know
cancelled
the
it.
WhatsApp is loud in the house here. So what I'm trying to establish here is that there's no formal letter from your office to either the board, members individually, or even the company secretary, saying that the minister would like to have a meeting with the board on this date and this venue and that time.
The communication that was made to the board members was made telephonically. And I think just to also emphasize the point that the decision to have the meeting was actually taken on the 11th, and I don't think it would have been practicable to use any other form of communication to invite the board members to to the meeting.
No, thanks, Miss. We'll get there. I'm just trying to establish fact. Yeah. So on the 11th of April, you take a decision that you want to meet an entity, essentially. And then that meeting is going to take place on the 13th of April. Your chief of staff, your PA, your advisor, or anyone, no one thinks that it is correct in terms of administrative justice that when a member of the executive wishes to meet a board or an entity, surely a letter should be drafted, a formal letter should be drafted, even if there is a follow-up by phone call that, company secretary, have you seen the letter from the office of the minister? I just want to establish that no such letter exists where the minister is inviting the board members.
No, there's no such a letter that exists. But I think it's important because so there was communication, and the reason, obviously, as I said, was because of the agency that was occasioned by the nature of the meeting.
Right.
I think it would have been impracticable. I think actually, I think the 11th fell on a weekend. Yeah.
Okay, I'll come that in my closing remarks. But I think a formal meeting should have been done through a formal letter and a formal invite. And I don't think it's impractical. I think if your chief of staff is able to pick up a phone and call about 8 or 12 or 6 people one by one, I'm pretty sure he's able to write a letter in 5 minutes saying the minister would like to meet with the board, with board members. But we'll come to that. Was there a written agenda for the meeting? So when you arrived in the meeting with these board members, were they presented with a formal written agenda in terms of what is it that we're going to be discussing in this meeting?
I indicated to them what we are going to discuss in the meeting. It was not written, but it was verbally communicated.
So another verbal communication. Do we have minutes of that particular meeting?
No, we don't have minutes of that particular meeting.
So members of the board are invited by the member of an executive. There's no formal letter to invite them. They're invited by phone call. When they arrive in the meeting, there's no formal written agenda. The minister communicates verbally. And even in the meeting, there's no formal writing or record of minutes of that particular meeting. You may or may not agree with me, Minister, but the courts of South Africa have made it very clear that when a member of the executive is exercising public power, remember when you are meeting this board, you are not meeting them as a comrade. You are not meeting them as friends. You may know them, in your different. And administrative justice is very clear that when you exercise public power, we ought to have a public record. And by you not having that record, it places us in a constitutional quagmire.
Look, firstly, the fact that it was someone from my office who communicated with the board members, it was not a friend of mine that I met in Eshabeen, shows that this was an engagement with the board and the minister. And secondly, and as I said, that the agency, that was occasioned by the need for the meeting. I didn't hide why I called the board members. I explained to them why I called them to that meeting. And I don't think that there's also a dispute in terms of the existence of that meeting. It took place in an office of our department. It didn't take place in my house or any of the board members' house. It took place at the offices of the.
But you'll agree with me, Minister, that there's no formal record of the meeting, in terms of the discussions that took place in the meeting. If Parliament wanted to exercise its oversight responsibility given to it by the Constitution to understand decisions that are taken by a member of the executive, maybe remove yourself as an individual from this.
Yeah.
Decisions that are taken by a member of the executive, part of what would need is a record of the discussions that take place in meetings which ultimately lead to decisions that are taken by members. And we don't have a formal record of that meeting.
I must emphasize, Honorable Lonzi, that the intention of that meeting was not to take any decision, either by the board or myself or jointly. The purpose of that meeting was to get a briefing from the board.
So it was a caucus?
No, it was not a caucus. It was an engagement with the board.
But you'll agree with me, Minister, that
I, as Minister,
even in your political party engagements, that where Parliament does not have any oversight, let's say somewhere in the SACP, or I don't know now, ANC, when you have the meetings, there are always minutes in a meeting, Minister. Because even as your own political party, where we may not necessarily have a role to play, but there ought to be a record of the meeting. This is what was discussed in the meeting. Board member A said this, board member A said this. It's only caucuses where you typically wouldn't have minutes. But in a formal meeting, at least I think we can agree that there ought to be minutes.
No. Like I said, the nature of the meeting, the agency that occasioned the meeting itself, in my view, you know, how the engagement also happened, which was me requiring a report from the board. And I must also emphasize that this was not the first time that I think I've indicated to you that we've had about 20 or more engagement with the NSFAS or its board members and so on and so forth. You know, I doubt any, you know, not every single one of those meetings themselves, you know, would have minutes or record, but it is either precisely because I want to have an understanding of what is happening in the institution, you know, or anything of the sort. And this was the nature of that.
Sorry to cut you, Minister. I've just got little time. So,
Honorable Sodana's got his hand up. Let's see what is wrong. No, thanks,
My
Chair.
hand is up, Chair, on the platform. Apologies.
Okay, I don't see it. I'll come to you, Honorable Manamela.
No, thanks, Chair. It's a follow-up on Honorable Lonzi's question, which I think the Minister's response is not satisfying. The Minister confirms that this was a formal meeting, even though it was communicated informally. But Honorable Lonzi is asking on our constitutional obligation to perform oversight. How do we perform oversight when the meeting was not recorded? So we want to know from the Minister. He says now that they are used to having formal meetings without records. I mean, we are very concerned about even that statement itself. But on the particular meeting Honorable Lonzi is referring to, the Minister must confirm that was it lawful or legislative according to how he runs the department of not keeping records of formal meetings, because now we can scrutinize what was the discussions or the briefing given by the board in that particular meeting.
Okay.
Can I rise on a point of order?
Yeah.
Chair, I would like to call order on the proceedings of the engagement. You have noted a list of people who will make submissions. And Honorable Msizane has been given an opportunity, 15 minutes to present. And it has now become a tendency that when you are given your time to present, you'd waste your time on issues that are less important. And during our presentation, you'd want to disturb our line of thoughts with follow-up questions. And my understanding is that a person who must present a follow-up question is the person who raised the question initially. Now I'm calling a point of order precisely because of these follow-up questions. They are not in any way aligned to the proceedings of the meeting. Thank you very much.
Honorable Manamela.
Thank you very much, Chair. Mine is also a point of order, Chair. Initially, because perhaps I'm hearing backward, and it's a point of order on the assertions or the utterances by Honorable Lonzi. Honorable Chair, where I'm seated, I don't remember and I don't think Honorable Lonzi has been a member of the ANC or a member of the party. As a result, a reference or an inference on how the ANC conducts their meeting, if we record meetings, how we call our meetings, would actually be out of order for him to make that inference. And I don't think it's in order. I think Honorable Lonzi should not make inference on how the ANC calls meetings. In fact, he should actually make inferences on how they call meetings and how they conduct their own meetings in the party that he belongs to. So I understand his question, but he must not make inferences to the ANC on this question. Thanks, Chair.
No, thank you. Honorable Ngubane.
Yeah, Chair, I would like to as well call an order on Ola Khabo. We've been doing this thing in all the meetings where we do follow-ups. And it has been happening for all previous meetings. So it can't be that on this meeting, when one member has a follow-up, now there is an objection on a follow-up first. And second, Chair, I'm requesting that there be a one chair in this meeting who will correct those follow-up. And there's no two chairs in this meeting. So please, Chair, if there's many chairs, we need to know now people who will correct other members while they're asking their follow-up. You have all the powers, Chair, and the intellectual to see if this follow-up is a correct follow-up or this follow-up is a wrong follow-up. Your judgment is very much sufficient. And I'm asking you that be the only chair that we know, and we don't have other chair that just come out on this very important meeting. Thank you, Chair.
Honorable Low.
Thanks, Chair. I think we must be very consistent as members. We have raised concerns last week in the portfolio committee on time management and how we're going to run the day-to-day run of the meeting. I'm saying all of this because we would have been mindful of the fact that we want to deal with issues and details. We said that we'll deal with 15 minutes after, members will get follow-ups after, so that we're able to have members to interact accordingly and have our face to move in that way, because we've made determination when I made submission to say these intervals, as we interact each other time and again, they will end up making us to be all over the place and haphazard, and we must be able to deal with time management. And I was very coherent when I raised that point, because I knew that we'll have to deal with our questions accordingly and we must be responded accordingly to deal with issues so that we don't preempt as to what's going to happen. So I want to agree with Honorable Kabo. Well, let's proceed with our questions 15 minutes and take follow-ups after the time when it's enough. It will give us a way to have the meeting, to have the quorum. Thanks.
Okay, no, thank you very much. Members, there's no need to fight amongst ourselves. We just need to agree that there are certain times where we're not going to agree. And if we don't agree, let's try and work as a collective. It's in the best interest of Parliament that we do so. This Mangwapangwapana won't help us. Let's stick to the agenda, which is to hold the executive accountable, as you are empowered by Section 55(2) of the Constitution to do so. So let's stick to that part. Honorable Manamela, I did not correct Honorable Lonzi earlier on when he made an example about us, because my understanding that hold on. No.
It's us, Chair.
No. Who said you must open them? You see, now we're going to have a problem. I gave you chance to speak. I'm responding to what you have raised there. Now hold on, Honorable Govan. I gave you guys to speak here. Now I'm responding to those, and I've just said you're not going to agree with me. I'm not always going to agree with you, but we are going to respect the sittings of Parliament, and you don't want us to exercise the powers that are conferred to us as chairpersons to make sure that our meetings run properly by disrupting us, opening our mics here when we have not been allowed to do so. It's not going to happen, Honorable Cesar. Honorable Manamela, I was responding to you that I did not example about meetings of the NC, because my understanding is that the party belongs to doesn't call meetings. So they just get told what to do there. That was my understanding. But if they do also, I apologize. So what I'm getting here, colleagues, and you must help us, is that you are saying if somebody is asking questions, there must be no follow-up from other members. If that's what you are saying, let's agree that it will be standard. And even you'll then note your follow-up on a particular matter, and then we'll then take it at a later stage. Is that what you are saying? Honorable Kaka?
You know, Chair, okay, I wanted to say, Chair, I generally as a human being do not like being embarrassed, particularly in front of people, and we're acting like kids that don't know what's happening in our own house in Parliament. The fact that in the middle of such an important conversation, we're disrupting each other on matters of housekeeping is quite frankly embarrassing. It is below the standard of our titles as legislators. Can I request, Chair, that we deal with the agenda, exhaust it, and then all housekeeping matters of ourselves that are troubling ourselves, we'll have them. The modus operandi that has been the order of life must continue unless we want to break and then have a housekeeping meeting on how we want to organize our meetings and then start from scratch. But in the middle of this, it's just weird. I don't like it.
Honorable Manamela?
Thank you, Honorable Chair. No. I've just lowered my hand. I'm persuaded by the member. I've just lowered my hand. Honorable Chair, my only request or my only plea was with you, because although it is an established practice that members can ask follow-up question, it does disrupt a flow of thought on a member that is currently given an opportunity to ask questions. So my plea is to you, my humble plea is to you to say, please do manage us if we are now getting into a level where we are disrupting a level of flow of a member that is accorded the opportunity to ask questions. But I'm persuaded by Honorable Hahau.
Okay. Any takers here? Honorable Lonzi?
I think perhaps then, Chair, a more balanced approach, which also maintains the precedence, is that if a member is on the floor asking questions and then another member would like to do a follow-up, maybe as the Chair you can put it to the member who is asking that, would you be happy with Honorable Khabu asking a follow-up? And then if I believe that, no, it's going to disturb me, I can say no. But if I've got no issue with it, I can then say yes. I think that balances both sides of the field. But I won't be distracted, Chair. When you come back to me, I'm very focused.
Any takers? So we've got the view that we must continue, Honorable Khabo, we must continue allowing members to ask if the member on the podium does not have a problem with that. It's a new rule that we are now bringing, because I know that some of you, when we get excited, you'll say that I'm bringing my own rules. So I'm putting it to you deliberately, because you've brought three different views here. And some of you tomorrow will say that the meeting degenerate because of my own doing. And when you know it's yourselves. So I deliberately put it to yourselves because I don't want people getting excited and creating impressions that it's because of me that we have you guys behaving like this. Honorable Lonzi, you still have 6 minutes.
Hey, my time was properly disrupted, Chair. So, but let me quickly finish here on the minister, and then I want to come to the board members. So what we've established here, Minister, is that you communicated a meeting invite to an entity without a formally written letter. There was no written agenda, and there were no written minutes. If I was as a member performing oversight, I wouldn't qualify that to be a meeting, because I hold the strong view that when a member of the executive is exercising public power, we need to have a proper record. I'm not persuaded that it's because of agency, because if the chief of staff has enough time to call individual board members, then he should have time to sit down and write a formal letter, which wouldn't even take 5 minutes, inviting board members to a formal board meeting. A letter that would probably have to be directed to the company secretary. So I've just got one question before I go to the board members. That question is, when that meeting happened, there is also an allegation that you confiscated the cell phones of the board members which were there. The second one is that not all the board members were invited to that meeting. So I just want you to clarify those 2 points. I know you like to give context, Minister, but please, if you can clarify that. Were cell phones of board members taken in that particular meeting? Yes or no? And secondly, according to your knowledge, were all board members invited to that particular board meeting?
And everyone who participate in that type of a meeting to leave their phones outside. There was nothing untoward. It had happened in a meeting before the board members. And there was no malice intended. It was just intended to protect the board. And I think, on hindsight, it was probably appropriate because I think, firstly, that engagement, which, by the way, may not necessarily have been a statutory engagement, but an important engagement for us, ended up, not just with you as an honourable member or with the courts, it also ended up in the newspapers.
With respect, Minister, yes. I don't want to cut you. The chair is going to be very strict on time.
Yes.
I think you've answered the question of the phones, yeah.
Yeah.
The second question, did you invite all the board members to the meeting?
According to my knowledge, all board members were invited. And the apology that I received was from the interim chairperson, who was traveling abroad, who had agreed that I can meet with the board members.
Thank you, Minister.
But subsequent to that, I learned that there was one board member who was not invited.
So do you see why it's so problematic to call a board meeting as a member of the executive and not communicate through the formal channels through a company secretary? Because now you have got a meeting as minister that you say is a board meeting, but at the same time you are saying there is a board member that was not invited. But had you communicated this thing formally through a letter, through a company secretary, where there was going to be an agenda, it was going to be the responsibility of the company secretary to ensure that every board member is invited. Because if there are board members who are not invited and board members who are not invited, that's not a board meeting. That's why I insist that it's as good as a caucus. But we'll come back after to make our analysis. I just want to put some questions before the board on the same meeting. I don't know who will take this. There's no record of the meeting. The minister has said that to us. In the meeting, did the minister instruct you to not proceed with the appointment of the CEO of NSFAS?
Yeah, no, thank you very much, Chairperson, and thank you, Honourable Member. I would have loved also to give a bit of a background, if I'm allowed, about circumstances of this meeting. Personally, I received, actually it was I missed a call. I didn't have the number. I returned the call. The gentleman introduced himself as Mandla, working with the minister.
Sorry to stop you. Chair, just a quick one. I remember in the beginning of the meeting you had said you'll allow a leeway. So can you allow this member?
No, I've paused time for them. I did say that.
Yeah, I remember.
Them. Yeah.
Thank you, Chair.
Yeah, thanks, Chair. And well, I responded to the call, and I got an invitation that we actually were needed to an urgent meeting with the minister, which meeting will take place in Johannesburg, but the details would be sent to me again via a text communication. I indicated then that I'm actually recovering from a surgery. I do not think that it will be practical for me to travel from Polokwane to Johannesburg. But he did indicate to me that the meeting was very important for the minister, and he pleaded that I actually avail myself. I considered. I went to the meeting on the 13th of April in Johannesburg. It is true that on arrival, our cell phones were taken, stored in different white, not brown, envelopes. All of us who came, there was no formal agenda to that meeting. In fact, there was no agenda. The minister took the platform and introduced our colleague, Ms. Mohale, as our deputy chairperson. I've heard the minister repeat it more than twice in this house, referring to Ms. Mohale as a deputy chairperson of the NSFAS board. Personally, I don't know why she's the deputy chairperson, but I know that in terms of the NSFAS Act, the NSFAS board may appoint a deputy chairperson and not the minister. I know we have not designated Ms. Mohale as the deputy chairperson of the NSFAS board. So that deputy chairperson was introduced to us by the minister, was requested to make a presentation on behalf of all of us as NSFAS board members. The presentation was made. It touched largely on issues within the purview of a committee he belongs to. She belongs to the HR committee. I don't belong in that committee. Some of the details I did not have. It was only after Ms. Mohali spoke that the two colleagues felt they needed to step in, and they corrected some of the things which were said. I could not have corrected them because the report that we were anticipating had not been provided to the board at the time. The second colleague who wanted to speak, and I'm raising this in the context of, was it an interaction with the board? It wasn't. It was an instruction session because Kumalo raised his silence after the two colleagues, and he was told that you are repeating yourself. Then it was my turn to raise a hand. And the purpose of me raising a hand was to indicate that my flight was ready. And that was within 35 minutes. I want leave of absence. And the minister said, no, we're actually about to finish. I would confirm the meeting didn't take more than an hour. It was a very brief meeting. But in that meeting, the minister's concern was really that we are going ahead with the process of appointing the CEO, and he was convinced that there is an instruction that he needed to give to us as members of the board, and that our processes should be paused pending that instruction that he would give us. If I remember well, I'd written my date down. It will be a Friday of the subsequent Friday. It would have been about closer to 2 weeks. I felt, and I think it was a feeling that we shared with colleagues post that engagement, that the minister's interaction with us could not have been a normal, lawful interaction between the executive authority and a member of a board of an entity. It is subsequent to that meeting that I wrote to colleagues using the WhatsApp group communication when there was no movement around the issue of the appointment of the CEO, which we had to move because the minister had given us a deadline, which deadline was actually approaching. I wrote in there, I addressed my text to the acting CEO and the chairperson and the colleagues. It was, dear chairperson, acting CEO and colleagues. And I said, I note that there is no movement on this thing of the CEO. And now this was my way of rejecting the instruction of that meeting that we should pause our activities. And I went further to say that I want an arrangement for a meeting so that we can finalize our processes. Chair, there were processes that actually preceded or development that preceded that meeting with and it answers twin questions that you have sent to us. The development that preceded that meeting is that on the 28th of March, that's the day I did my surgery, I missed a call, and that call was from one of the colleagues I know from Limpopo, Mr. Letlogonolo Masova. Mr. Letlogonolo Masova is one of the administrators appointed to one of the sitters. I don't remember which of the sitters, if I'm correct. So I think I've got a text because I didn't want to misrepresent what he said. But the essence of it, it says, Mushati, can I please steal 2 of your minutes to brief you about my issues? And I emphasize the following point. I'm just a messenger and due to meet with the principal shortly. I did not respond to this because I was not in a position to take a call on that day, but I did call Mr. Masoga the following day, and he tells me that the minister, that's the minister responsible for higher education and training, was not comfortable with the trajectory we're taking as the board in relation to a candidate that will potentially be appointed as the CEO. He did inform me that there is a very strong candidate, and he gave the credentials of that candidate, who is someone he referred to as a candidate who had been with the National School of Government for some time, and he did indicate that he was a strong candidate. And I said to him, these are the exact words I used. I said, I do not have history of defying leadership. That is what I said. And this was my way of dismissing him because I did not want to venture into discussions around that subject because we had agreed when we started the process of recruiting the CEO that we needed to guard the integrity of that process with everything at our disposal. And it is for that reason that anything that could easily dismiss someone who seeks to interfere would be an immediately available weapon to me. But it was not only Mr. Masoga who called me. It was later, I think on the 7th of April, I received a text from Mrs. Mohali, who was introduced as our deputy chairperson in the board of NSFAS. And she wanted to check if I would be available for a call the next day. I indicated that I was available anytime from 9 o'clock in the morning to take her call. I think around that time of 9 o'clock, she didn't call. She actually texted that she was in council. I understood it to be a council of the, she serves in one of the ICASA, council of ICASA. I understood it to be a meeting of ICASA. And then, but she did later call around 4 minutes to 4. And that's where she explicitly told me that the minister is of the view that Mr. Wasim Karim is not ready to take up the responsibilities of being a CEO of NSFAS. He repeated almost the same language from Mr. Masoga, that there is a strong candidate who should be considered. My response to her was, actually leadership had already engaged me through Mr. Masoga, so there isn't a need for us to go further with this one. We should be okay because leadership has already engaged me through Mr. Masoga. So that is the context that I needed to give. The issue of the cell phone, I think I've dealt with. It was on the 20th of April, that is, would be almost at 5 o'clock, that's 16:47, that I received a call from Mr. Masoa again. And this call now comes after the HR committee had done its work. That question, whether the HR committee did finally do the work, it did the work. The report is available. I'm not sure if members of the committee would want it. A report is done, signed by all persons who needed to sign that report, indicating the process, indicating the panel, indicating the scores, indicating the recommended candidate, and everything. We've got a report. So the board has that report. And this time, Mr. Masoga says to me that I got a call from Sis Florence. And this, says Florence, was in reference to Mrs. Florence Masebe, who I understand to be the special advisor to the minister. She was also in that meeting of the 13th of April. And he says, Mr. Masoga, that the concern from says Flo is that it appears that the HR committee acted outside of the expectations of the minister. And I said that I had not seen the report of the HR committee at that time, and I couldn't comment further. So that speaks to, in my view, what I consider to be the level of interference. But then there was a pushback. This is a pushback that was designed to ensure that ultimately, and I think the pushback comes after all these attempts could not be successful, the pushback to ensure that the meeting of the HR committee is frustrated to a point that the board cannot see it. And this is available. There are exchanges. I think in one of our WhatsApp group, you would find exchanges that are dated 10th April, where Ms. Mohali introduced this thing that suggests that there is no readiness to go to the board because seemingly some of the panelists who are DDGs in the Department of Higher Education were not there. I didn't understand the relevance of those DDGs because their role were, they were panelists. The panel had done its job. You no longer need panelists now, you need the HR committee. But for some reason we are told that the absence of these DDGs would make it impractical for the HR committee to finalize its job. And Ms. Mohale emphasized the point. We will not have that board meeting until the HR committee has done it. She's the chairperson of the HR committee, by the way. And we will not have that meeting. And she's supported there by the chairperson of the board. These are the two individuals who then, after finally the HR committee met, who then on the eve of that board meeting since resignation, and I'll emphasize about resignation. I only saw a resignation, the acting chairperson's resignation, which resignation made reference to Ms. Mohale's resignation. It would appear that the Ms. Mohale, in resigning, somehow forwarded it, but I have requested the company secretary that can we see for the purpose of record Ms. Mohale's resignation. I've not seen it, but I know it was a reference to in the chairperson's resignation. So, Chair, I think that would, in brief, respond to the question that you have asked. Thank you.
So, I just want to understand here. So, at least now you have established that you were called to a meeting without a formal letter, without effectively a formal invite, right?
That is true.
It was via phone call.
That is true.
And then when you arrived in the meetings, your phones were placed in white envelopes, not brown envelopes.
Not brown, Chair.
Then when you entered the meeting, there was no company secretary to take minutes.
There was no any of the support staff from the office of the NSFAS.
And the minister was there.
The minister was well supported.
How did the minister give you the instruction to not proceed with the appointment of the CEO? Are you able to remember what exactly he said to you?
The closest to the exact word was that you are not supposed to proceed until I give you further instructions, but he then gave us the date. The date, I think it was to be the subsequent Friday.
So what did you understand about further instructions? Like what does it mean by that?
I wouldn't want to invite myself into speculation, but whatever I understood at the level of what our powers are as the board is that the board is empowered to appoint the CEO, and this process of appointing the CEO has got no participation of the minister. The minister comes after the fact. The minister comes when we have made the appointment as the board, requesting him to concur only in relation to the condition of service, and that concurrence is a joint concurrence between him and the minister responsible for the finances of the Republic.
So when you were in that meeting, did you perceive that to be a meeting, or you just perceived it to be a caucus between board members and the minister?
It was a meeting, a strange meeting.
A strange meeting. And then, do you also confirm that not all the board members were invited?
I interacted with Advocate Lavant after the meeting because he was absent. I told him that you were not in the meeting, we were meeting with the minister. He told me that he did not know about the meeting, so he was absent.
So how do you have a board meeting where not all board members are invited? What type of a meeting is that?
I've said, Chair, that it was strange, but remember we were invited on the authority of the minister and as an entity that reports to the minister who represent the shareholders who are the people of the Republic of South Africa. We went there hoping to attend a meeting, only to find when we arrived that it is something that is designed like a meeting, but it looks differently.
And then my last question, Chair, and this is so that we can have a balanced view. And I'll tell you the importance of this question. You must not think that I'm fighting with the board, because we've got many entities that have boards in this sector. And boards have got a fiduciary responsibility to perform their duties. Now, although I can say I sympathize with the strange meeting and arrangement, but I want to believe that if you are a board member who's a professional, who's got a fiduciary responsibility, even if a member of the executive gives you an instruction, if you hold the view that that instruction is strange, is unlawful, is irregular, surely as a board member, you have got a duty to not implement an unlawful instruction.
I agree completely, and that is exactly what we have done. I've mentioned earlier that as soon as I had formulated the view that you are canvassing, I went back to my colleagues that let's proceed with the work that we are tasked to do.
Thank you, Chair.
Yeah. Honorable Khabo. Oh, okay. Before Minister.
Thank you. Thank you very much, Chairperson. I think there has been some statements made by respectfully the board members, and I think it's important that I say a few things. Firstly, just to emphasize that the meeting of the 13th of April was convened by me as a result of my discussion with the interim chairperson, and secondly that that meeting, although not a statutory meeting of the board, but it was an engagement between myself as the minister with the board, and thirdly that all the board members were there in a meeting in November where the same thing applied, where we're meeting with the around the resignation of the then chairperson, Standa, who had resigned, and the same process applied, where we all handed in our phone. This is a practice that happens in order to protect the secrecy of our meeting. There was nothing sinister, and I believe either on the meeting of the 10th or on the meeting, of the 13th, if members of the board had objections about either their phones being taken or about being in a meeting where they believe there is no agenda, or that there's something inconsistent about my engagement with the board, that the board members would have actually indicated. I regret the fact that there was one board member who was not invited, and I think we obviously should have handled that properly, but also I think all the other issues that have been raised. The board members themselves in their application, I'm quite surprised that I'm said to have issued an instruction in that meeting. The instruction that existed to the board, which was in writing, was that the board had to appoint a CEO latest by the 31st of May. Now, the question of what actually happened in that meeting, where I was given a report, I may have made some mistakes around the role of the chairperson of the Human Resource Committee, and referring them to as deputy chairperson. But I think importantly, the understanding of that meeting was that the board cannot go ahead and appoint a CEO in their board without having concluded all the processes that was required. And I did emphasize in that meeting that I'm the one who has given them the deadline, and the deadline is only on the 31st of May. And upon conclusion of the entirety of that process, that that the board should furnish me with a report. I did not tell the board to hold the process. What I actually advised the board is that that process needs to be concluded. I cannot comment about the discussions that the former board member has had with the various people that he's referred to. I don't think I'm in a place to do that. But importantly, I have not in any way instructed any of the board members to act in a way that would have undermined their fiduciary responsibility, either in that meeting or in any other meeting that I've had with them, or even outside of the meetings of the board. I've at all times acted in as expected of me as an executive authority, and I maintain that. And obviously, I think as indicated, beyond what what we say here, I think I've indicated that this matter is also before the courts in terms of its determination. But I stand by my word that I have not in any way sought to interfere with and in fact the report that the former board members are referring to, its details, I became aware of it when they were splashed all over the newspapers the following weekend. Thank you, Honourable Chairperson.
Thank you, Minister. I see the hand of Portia's iPhone.
Yes, Chair. Can I go on?
Yeah, are you in a position to open your video?
Okay, I will do so. I've opened it. Can I go on, Chair?
Yes.
I am one of the former board members, and I would like to support Advocate Ramashia in what he has alluded to so far. Yes, the minister said we should go ahead with the meeting of the HR committee, but before we go to appoint the CEO, we must hold on. He will call us, and then he will have a meeting with us before we can go on for appointing the CEO. So it's true what the advocate is saying. Thank you, Chair.
Okay. Maybe in the interest of time, if we are covered, let's say we are covered, so that we don't repeat.
Just 10 seconds, Chair. I'm not asking a question. I'm saying maybe you will have to assist us on this. We can either discuss it during break or what. Because what we effectively have here is that we have people who are attending Parliament in the form of the Minister and the board. And both of them are presenting diametrically opposed versions of what happened. So what we know is that someone is lying, but we may not necessarily know who is lying. So perhaps during break, legal or researchers may have to make us to understand how do we deal with this constitutional problem, because two people are speaking under oath and they're presenting different versions. How do we know who is telling the truth and who is not?
Yeah, you've made the point, Honorable Khava.
Thank you very much, Chairperson. Let me just go straight to issues. Honorable Minister, I believe that you are aware that as the ANC, we are currently on a serious trajectory of renewal. And as part of our renewal project, we should move beyond tick box or box ticking to actual accountability, where serious actions has been taken. And I'm raising this because we appreciate your ministerial powers that you have exercised in terms of placing the board under administration. But we believe so that as part of playing our oversight, we should be precise in terms of developing an understanding on the process that has been followed. The collapse of NSFAS, in your view, it cannot be looked into it apart from or in isolation from the role of the department, from the DG and the DG's executives. I believe that the department has an oversight role to play on and around NSFAS. And with that being said, we can also, like I said, believe that NSFAS exists in isolation or in an island. Let me start with this question. Can I get clarity from your good self, firstly, Minister? Who is Mandla? Can you give us the name of Mandla with the surname and the position?
Mandla Shabalala that's the person who called the board members. So that's Mandla Shabalala, who's the community and stakeholder relations manager in the office.
So would I be right to conclude that he was acting under your instruction?
Yes, he was.
Okay, let me just go to the issue that has been raised by the board, by one of the board members. There is an allegation that you had instructed the deputy chair, whose appointment or election is under question as the deputy chair, to speak to board members on your behalf. Have you done that?
No. I didn't instruct anyone to. I've maintained constant communication with the interim chairperson at all material times.
So would it be right to conclude that the deputy chair, Ms. Mohale, was acting outside your instruction?
I did not instruct anyone to act on my behalf as it relates to any of the matters relating to that.
Thank you very much. The second issue, Minister, there is an allegation that one of the administrators that you yourself has appointed as an administration of service sitter has also made the very same call, dropping your name, claiming that you have instructed him to lobby board members to take a particular route in terms of who would be best suitable as a candidate of the CEO. Is it true or not?
Well, like I said, I haven't had any discussion with anybody around the question of the appointment of the CEO of the NSFAS.
Thank you very much, Minister. Let me probably go to the board. Like to check with you, was this the first session or meeting you had with the minister where your phones were taken?
This would have been the only, and perhaps also indirectly touching on the comment about possible 20 meetings. Our total meetings with the minister have only been limited to 5 in as far as I'm concerned. And of the 5 meetings, I honestly do not remember my phones being confiscated.
So this is the only meeting where your phones were taken?
I don't want to answer it that way, but I honestly, my colleague wants to answer it directly, but I do not remember my phone being taken.
Advocate, you are the one who have been leading the charge. And you are saying, out of the 5 meetings,
yes,
this is the only meeting. I mean, there's only one meeting where your phones were confiscated. Am I right to conclude that is what you are saying?
You will be right to conclude it as a submission that I'm making.
Okay, fine. Let's then go to the next issue. You raised the issue of the deputy chairperson of the board, Ms. Mohale. And in your submission, you are giving an impression that you never said as a board to elect Ms. Mohale as a deputy chairperson. In fact, that is a responsibility of the board, not of the minister. Did I hear you right?
That is correct.
In that instance, how did it happen that Ms. Mohale became the deputy chairperson of the board?
No, she has never practically been the deputy chairperson of the board. She has only been introduced as such by the minister, both in the meeting of the 13th, but also the minister has made at least twice in this house a reference to Ms. Mohale being the deputy chairperson of the board.
So, would it be safe to conclude that the board has never elected Ms. Mohale, rather Ms. Mohale was imposed to you as a deputy chair, contradicting the legal prescripts that guides the process of electing deputy chair?
Yeah, that would be unfair to say imposed. I think the fairest thing to say is to say the minister has constantly referred to Ms. Mohale as a deputy chairperson. Perhaps he interacted with her as such, but for all practical purposes, Ms. Mohale is not the NSFAS deputy chair or a former chairperson of the NSFAS board. The board has never appointed a deputy chairperson.
No, thank you very much. Let's go to this meeting of the 13th that you said is either informal or formal. We are still confused, but we'll deal with that issue. How did you attend that meeting? Who financed your traveling? Was it the department or you funded your own traveling?
No, NSFAS financed the meeting.
NSFAS financed the meeting?
Yes.
An informal meeting?
At least at this stage, we can agree that it was an informal meeting, but at the time we received an invitation and accepted it, it was supposed to be a normal meeting organized by the minister.
Not a problem. Let me go to the issue of legal. Minister, when were you informed that the board appointment process was made with legal defects?
This was almost as soon as I assumed office. I think the first time I interacted with that information was around August, September.
Okay.
Yeah.
So did that process, was it you who initiated that process of verifying whether the process was legally compliant, or is it a report that you found in your office?
It's so we had a report that was presented to me, but there were also I think some complaints, especially from students' organizations, who were complaining that they were not represented.
So that is a report that you got on your appointment?
Yes.
Okay, fine. Let me go to the legal department. Advocate, can you confirm or deny whether the department, through your good selves as the legal team, has formally cleared the appointment process of the board done by the previous minister? Did you formally clear the board after it was appointed?
Thank you for the question, but I'm confused. What do you mean by clear?
Okay. Did your office issue a formal legal opinion on the state of the board that it passes all legal aspects? My assumption is that before the minister could go out and pronounce any decision, as the legal team, you should be able to advise the minister or department as to whether this matter will hold water if it could be tested legally. Have you had that opportunity?
We were never approached.
Are you saying that the former minister never approached you when finalizing the appointment of the board?
Not as far as I can remember.
DG, can I get your take on the matter? Why is it that we are having a board that cannot pass the legal standing?
Thank you. There were a couple of issues about the previous board, and some of those issues were presented and discussed in this house as well. One of them was that the gazette that was published went beyond the minimum requirements as in the law by adding a master's degree as
DG, we are running out of time. I'm left with 3 minutes here.
Okay.
Was the report, did you give the report a green light, yes or no, on the appointment of the board?
No.
You did not agree with it?
No.
Is there anywhere in writing where you've advised the minister, the previous minister, that actions of appointing the board would be inconsistent with the law?
There were meetings, there were discussions, but it was made to me very clear, and the minister herself indicated that there was no role played by the officials in the decision about the board.
Thank you very much. Can you also provide that in writing, that one? Can we go to the second issue? On the self-reviewal process, I believe that at the center of this problem is the legitimacy of the board that the minister wants to cite. I want to check with you in terms of the advice that you have provided. Is it you have advised the minister to go on a review?
We sought an external legal opinion.
You sought an external legal opinion?
Yes.
So the process of instructing the board to start the process of appointing the CEO, was it done during that time when the matter was before the court?
Yes.
Meaning that the minister has identified certain areas that are inconsistent with the law on how the board was appointed. And the same minister is the one who has instructed the very same board that he has viewed as unlawfully appointed to start the process of the appointment of the CEO.
Can I respond? Remember, in minister's presentation, he referred to the Odekral principle. And that Odekral principle is, in essence, saying even if the board was unlawfully established, the work that they will be doing in the meantime will only be set aside by a competent court of law. And because the self-review was still in process.
Fine.
That's
my question is,
yeah.
Is it you who advised the minister on that process of self-review? Is it you as a department or what? That's my question to you.
I had said we sought an external legal opinion, and that legal opinion is the one that advised us as a department to advise minister as such.
Let's leave that part of the legal opinion. Minister, let's deal with this issue of the meeting of the 13th. There is an allegation that, in a way, you had called that meeting to instruct the board on who to appoint as a CEO. That is the impression that has been created in the society. And the number of allegations that has been leveled here against you in terms of how you have handled the process. And I would want to ask you a straightforward question in relation to the issue. Has there been an instance where you are instructing the board on who to appoint?
No, I have not instructed the board on who to appoint. And I think if I had instructed the board on who to appoint, or if I had wanted to instruct the board on who to appoint, I would have definitely instructed them on that. I understand where my powers lies. My powers in relation to the appointment of the CEO of the NSFAS only lie in as far as concurrence with the decision of the board. So I know my place.
So according to you, it's fine, Minister. According to you, were you not technically confirming the board that you are questioning or that you have placed the matter before court by appointing additional or by co-opting or agreeing to the co-option of additional members of the board?
No, I didn't agree to the co-option of additional members of the board. And the reason why that wasn't going to be material was because I've already approached the court to review that decision. And I must say also that in the bigger scheme of things, it's not just the appointment of the CEO that the board was responsible for. We're talking about a 60 billion, close to 60 billion rands budget, which we had also, that the board was responsible for. So that continuation was itself, in our view, legal for the board to continue performing its board. I would not have in any way tried to interrupt a process which I had instructed the board to commence with.
The last one, Minister, because I've run out of time. When you were conducting or were initiating this process, where it's dictated that you must consult with the board, have you ever written formal individual letters to every board member? Or that engagement where they believe was not a formal meeting, it was just an informal session? Have you ever written, because clearly there was no formal engagement or consultation, is there any formal letter that you had written to board members in relation to the process?
No, I didn't write any.
Thank you very much, Minister. Thanks, Chair.
No, thank you very much. Honorable Ngubane, you're supposed to come in. Can I please bring in Dr. Christians, because of the matter I spoke about earlier on. And then we'll come after. Dr. Christians?
Thank you very much, Chairperson. Chairperson, Minister, I would just like to get back again to the purpose of the meeting that you held, because it seems that is the bone of contention in the room. So, it was alleged by the board members that they were required to surrender their phones and they were not provided with an agenda and that there were no minutes recorded whatsoever. So I just want to establish, was this an official governance meeting? Was it a consultation meeting? Or was it just an informal engagement?
This was an official engagement between the board and the minister. It did not have, it was not a statutory board meeting where the board was expected to make a decision. The purpose of the meeting was for me to get to understand the concerns that the interim chairperson had raised with me as it relates to issues around governance and the processes of the appointment of the CEO.
Okay, thank you Minister. So that then leaves us with a very uncomfortable question. And that is, how are we as Parliament then expected to verify between what the board has said and with what you are saying? How are we supposed to verify that in this meeting if there is no valid evidence of that meeting and no minutes after the fact?
Look, I mean, I think on hindsight, and given the fact that, in the intervening period, there has been, official record and communication between myself and the board, an official record including the instruction that I've given to the board, to expedite the process of the appointment of the CEO. And I think subsequent to to that, the various other engagements that we've had with the board. So because that engagement arose as a result of the ongoing engagements that we've had with the board, I didn't think that at the time that it was important, and I agree with you that probably on hindsight, given the fact that there are issues around this meeting. But I think the important thing, Honourable Christensen, is that I haven't heard from the board, even today or on any other day, them saying that I gave them an unlawful instruction in that meeting. And I think for me that's what's primary. Them saying that I sought to, in that meeting, interfere, other than me having said that they need to, conclude all the processes relating to the appointment of the CEO as required by the regulations before taking that decision.
Okay, I think, Minister, it is really very clear that from a governance perspective that we do sit with a fundamental issue that it is not, in this case, or was not good governance practice to deal with a meeting of such importance without a formal agenda, without any minutes, and without placing it on official record. I think we all agree on that. I just want to get to the parliamentary legal services again. So we've heard now competing evidence today regarding instructions that the minister allegedly gave about a CEO appointment. Now, in your opinion, how would you suggest that we as Parliament satisfy ourselves? Seeing that there's no official record of this meeting, how do you propose we satisfy ourselves that that meeting actually existed, what transpired in that meeting, and what would be our way forward?
I'm sorry, I thought you were talking about the parliamentary legal. I'm not a parliamentary legal service.
DHET legal?
Yes.
So you wanted to answer?
Yes.
Okay.
I think the papers that were filed would have helped if the member had sight of before we came to this meeting, because that is where a lot of the issues are ventilated. And I'm still trying to remember whether the board members themselves have actually raised this as an issue in their papers. And maybe it would help all of us if we were to wait for the court to make a determination about this matter, because there are conflicting versions of what happened on the day, and the papers that the board has drafted and that minister has drafted, they have to stand and fall by their papers when we approach court. Thank you.
Thank you very much. I think we can get back to parliamentary services later on, Chair.
Okay,
because
maybe
I think
before.
it's- oh,
Maybe before. Do you mind if Honorable Lonzi has a follow-up?
Okay.
Now, me and Honorable Christians were forces, Chair. No, just when Honorable Christians had put the question to the minister says the board members didn't say that he gave them an unlawful instruction. And I beg to differ, because if I heard the board members correctly, they did actually say in this parliament that the minister gave them an unlawful instruction. So I just wanted us to confirm with the members themselves, because I heard that, and the minister is saying they didn't.
Thanks, Chair. I would like to hear from Parliamentary Legal Services, because I do think that's going to give us as the committee a way forward in this. But I would like to leave that to the end, Chair, because I just have just a few very other important questions to ask. So, Minister, you knew that we've now verified from the questions that you've answered that you knew from the start of your appointment that the board appointment process was unlawful from the outset. So why did the department and its legal unit then, essentially the ministry failed here, as far as I can determine, because they did not identify and correct what you say you now knew from perhaps the inception of your appointment, that you identified these defects in the appointments. So how come that proceeded then after all these months and you knew about the defects in those appointments?
Well, as I said, so as soon as we were legally advised, I then had a consultation with the board. I think it was on the 5th of November. And upon consultation with the board, I then went on to approach the court for a self-review. The various other options in the Act in terms of the dissolution of the board were not applicable in this instance. And I must emphasize this point, that the composition of the board, as we've said, to them and also elsewhere, was not the result of their own fault. They did not appoint themselves. And so the person who appointed them, who on the 20th of February, who in this case is the Minister of Higher Education, was then required to approach the court and ask the court for a declaratory a declaratory order to set aside that, that decision. So that's where the self-review comes in. So action was taken in that regard.
So, Minister, did your legal advice then recommend the administration?
No.
My next question, Minister, is NSFAS has now been placed under administration and no independent investigation was done. And I think, to me, that is the single most serious flaw. And while I know it does not appear in the NSFAS Act, it does appear in the Higher Education and Training Act. So no independent investigation was done. Why was that not preceded before your decision to place NSFAS under administration?
Well, as I said in my presentation, Honourable Christians, that the provisions for, in terms of Section 17A to D, stipulates the various, conditions within which an administration could be put into place. And safe to say that the review process itself may have led to, either where we are or any other alternative in terms of administration. But I believe that the conditions which were required by the law, which is not just investigation, but various other conditions, that those conditions were met, in terms of the, placing the entity under administration.
So, Minister, that brings me then to a question that I deem very important and very serious, because NSFAS has now been placed under administration for the third time. The previous two administrations were not effective. In fact, NSFAS has regressed, as we've seen. So at what point, Minister, are we going to admit, or government itself, are we going to admit that we have now implemented repeated administrations and we are merely treating the symptoms of NSFAS's failure, and we are not fixing the institution itself, the problems that exist within NSFAS? So we are going around in circles. Instead of managing a 50 billion rand, almost 60 billion as you have indicated, plus institution properly, we are now at the point where NSFAS is under administration for the third time. So I'm asking you, Minister, if something is not working, isn't it time that you think we overhaul and we revamp completely NSFAS? Because something must drastically change here, and a third administration is not it. Isn't it time to admit that NSFAS, in its current way and form, has failed, and that we need to rethink policy and rethink the entire system of NSFAS?
Well, I don't agree with you that the previous administrations failed. The first administration under Dr. Randall Carlson did not fail. And then, subsequent to that administration, there was a board that was appointed, and the then minister, Dr. Nzimande, had to institute another administration under Nomvalo, who did not complete his term as an administrator. The board was then appointed in state. So I essentially do not agree that the administrations have failed. But as I also said, that we are having that discussion around a sustainable student funding model, and I think it would be on the basis of that we should then consider what options are available on the table as it relates to the platform to distribute student funding. But for now, I think the current tenure of the administrator's intention is to stabilize the institution, ensure that we modernize it, and in that way we can simultaneously have discussions around what reform measures are in place. And part of the things we will obviously have to consider are the proposals that you're making on what needs to be done. But I don't agree that the previous administrators failed as presented.
Thanks, Minister. Then I think we are going to have to agree to disagree there, because none of the problems were solved. In fact, the problems have increased, and most of NSFAS's problems have arisen because of repeated administration, that repeated dysfunction within NSFAS, with new members coming on board every time. So the problems do not merely exist with the board members. There are legal vulnerabilities. Administrators come and go. We don't get any close-out reports. So those are definitely serious defects in NSFAS. I just want to get to the board members. So we've heard a lot of what you have said, and you've now essentially argued that the administration that the minister has placed you under is unjustified. Am I correct in saying that?
You are correct for many reasons, and at the center of those reasons is the fact that the reference, first, maybe let me start from the minister's attempted consultation. The minister writes to the board, respond to me within 48 hours. This is a list of my concerns. When the minister goes out public to announce administration, none of the issues that we made representations on are part of the reasons that informs his decision. He after the fact, manufactures or engineers new reasons that are not consistent to the reasons that are in the consultation letter.
Advocate, I'm afraid I must disrupt you there, because I think that's part of what you are arguing in court. That part, no. You're not arguing the reasons provided by the minister in court.
Maybe Chair, and I'm not sure you'll guide me. As the former board members, we also took legal counsel on the question of sub judice. And we understand the limits in terms of which we can stretch ourselves. And we operate within the guidance we got from our lawyers in as far as the concept of sub judice is concerned. And we are convinced that we are not breaching that line.
Yeah, you also listened to our legal when we started.
Yes, Chair.
And that's what we are basing our running our meeting from, that advice. And I'm saying, and I understand that you may have more information, like for an example, the advice that you're talking about. But my issue was, in court, taking into account what we were advised earlier on. In court, you are not arguing there, because in my view, you enter in the merits of the reasons which you don't agree with. And I'm sure in your court papers you would have raised those issues.
See, Chair, I think the horse has bolted. The minister made the reference to section 17 capital letter A, B, and C. And this response we are offering, it is based on 17 capital letter A, B to C. And it is important that we give this response because the minister has spent a lot of time on section 17. And we are saying to Parliament that the minister misdirected himself or had a wrong understanding of what the section requires. And we request time to impress on this point.
Yeah, do you understand my concern?
Yes, I do, Chair.
And my concern is that we were advised here in this meeting, in your presence, on not crossing the line to the merits of the case. And to protect our meeting, I'm asking that don't cross that line to that side.
I understand completely, Chair. I agree with you.
Yes.
And I'll limit myself very briefly.
Sure.
Chair, section 17, capital letter A, both A and B, I'll start with A and B and I'll combine them. Both of them, and it answers the question that the honorable member raised earlier about an investigation report. Actually, A and B requires that report. It is not absent, honorable member, in the NSFAS Act. It is there. It says it should be an AG's report or a report commissioned by the minister for that purpose. That report of the AG does not exist because the minister cannot accept the president saying to him, sometime in 1999, this thing happened in the Department of Education, it causes us embarrassment, as a result, I am removing you as minister. It cannot be fair to say a board of NSFAS should be removed from office because there is an audit report of 2023-2024. So the parliamentary requirements are absent. What are those requirements? It is an auditor's report. It is a ministerial investigation report. They are absent. That is what A requires. That is what B requires. And it says, A, these reports should point to financial mismanagement or maladministration. It cannot be maladministration by successive boards that preceded these boards. It can't be. That understanding is far-fetched. It should be a financial mismanagement by a board that is to be placed under administration. And the third reason the minister has considered does not arise because the board of NSFAS has not requested to be placed under administration. I'm saying, Chair, in terms of the applicable law, the law that you have approved, if this parliament wanted to give the minister more power than the powers provided in A, B, and C of Section 17, it would have added D that will probably have read or any other consideration that in the opinion of the minister warrants administration. The lawmakers have not given the minister that power, and the minister cannot give himself that power. Thanks, Chair.
Yeah. To the defense of the minister, you may differ that the report is not yours. The AG's report is not yours. That part is granted. But we can't say the report doesn't exist. We do have an AG report which the minister is basing. I agree with you that we may differ, that it does not belong to a financial year. DG, even this door is open. So I just thought I must just clarify that part, but I think the point is well made, and
thanks, Chair.
Yeah, we have 9 seconds, Dr. Christian. Maybe the last question.
Thank you very much, Chair. So you as the board, you've said that you are quite capable of governing NSFAS. And if this is indeed true, can you tell us then why have so many board members resigned? From the initial board member, Dr. Stander, why did they resign? Why leaving the board? Because that has brought the initial instability in NSFAS. And added to that, there were more board resignations. So why the board resignations? Because that caused the initial instability in NSFAS. Can you just explain that to us as an ending?
Very brief, because my colleague wants to take the second part of your question. You don't have to take our word for it when we say that this board has been very effective. You can actually directly reference what the minister says in his own way. He says, when he was addressing the National Assembly on the 24th of January, importantly, NSFAS performance has improved.
24th of February, not January.
Yes, it's February. Yeah. NSFAS performance improved. For the first time, students knew their funding status before the matric results were released, and continuing students knew their status of the previous academic year. The minister continues on the 14th of November, the minister says, it should, at this point, make it clear that the new NSFAS board has not in itself committed any wrongdoing and has not, to the best of my knowledge, done anything warranting a sanction. And this is important for lawmakers to underline. The minister says this board has not done anything to warrant a sanction. That is his own words. He says later that this is on the 14th of February. This February, a few weeks ago, the minister says, I admit that the NSFAS board has been working since its appointment in February of 2025. As things presently stand, I am mindful that the board is fulfilling its mandate under the Act. You don't have to take my word for it. That is what the minister says. Before I give it to my colleague, the emphasis on 18 board members versus the remaining 7 is emphasized wrongly. It is actually 13, not 18. Thank you.
Yeah, and there is a coincidence here between the resignation of board members and the threat of self-review. So some board members resigned just in coincidence with that self-review, and some resigned just in coincidence with dissolution. So you can draw the pattern.
Thank you. Honorable Low, maybe let's take you. I'm mindful of we should be going to lunch, but there are members who are going to leave. Maybe let's take Honorable Low.
Thank you, Chairperson. Me Kunta wa legal. Me
Kuta.
Okay. Sorry, I want to check, does the legal provide legal opinion only when they are approached, or when do you often provide legal opinions, or how do you operate in the space of your legal unit?
It can both be when we are approached or when we are in a position to provide one. Maybe we are in a meeting and there are legal questions raised. So it can be both.
So in your day-to-day running as a legal person, how do you report? In our as per the Public Administration Act of South Africa, we are required to report quarterly and give opinions onto issues of importance. I'm raising this because of time and again, the department has been found wanting with regard to legal opinions, and the department is finding itself to court, even though sometimes does not need to court. What is your view as legal? Is it that this is disregard of your opinions, or what is the problem? Thanks.
Maybe you'll find this as controversial. I actually like it when we have to be taken to court, because the courts will determine who is right, who is wrong in the interpretation of what the law says. And in this context, when we are approached to provide a legal opinion, we do just that. And when we are not, we will not voluntarily provide a legal opinion when we have not been asked for one.
Okay, it's fine. Let me not go there, Chair. It's going to take my time. I've got 15 minutes. In my submission, I think we should agree that the legal of the department must look onto the issues, because we can't speak of cost containment, we can't speak of making sure that we run government according to the law in terms of avoiding to go to courts. And the reason there's a unit for legal to be there is to avoid courts, advise, align, consolidate, and mitigate, and make sure that we are going to deal with all of the issues. So we'll get to the issue of legal. Minister, in one of the submissions, as I was listening to the board member, the board is, as per your submission, did the minister hold the NSFAS board responsible for the 2025 audit outcome, even though they were only appointed on mid-February? Because I went to my notes, and the disclaimer of opinion relates to a period when administrator oversaw the affairs of NSFAS and was still waiting for the close-out report of the administrator. Can you clarify that too? Did you take them based on the fact of the audit outcome? And then did you take them based on the fact that the close-out report of the administrator is not yet closed? So we can clarify the contradictions. Thanks.
Well, I mean, I think it's based on several factors, but including, the question of the AGSA's report, and then. So as I said, I mean, the second administrator, Nomvalo, was appointed for a period of 2 years, went on to serve, I think, just under 10 months, if I'm not mistaken. I just have to calculate. And there has been disputes, even before I came into office, around handing over the report and not handing over the report. So I think that's an issue that's still there. Yeah.
Thanks, Minister. Also onto the board, is it true that you gave directive as per the allegations onto the board with regard to the audit progress outcome for the 30th of April to the 31st of May? Have you ever given a directive to the board on those dates?
No, the only directive that I gave to the board this year was on the, I think, 27th of March, which related to actions that needed to be taken from the Auditor General's report. Yeah. So that's the only directive that I've given to the board.
Have you ever received a report from the progress report from the board between the months before that you could have dissolved them?
No, the only time we received anything relating to that directive was when the board also responded to, to my letter of the, I think, 27th or 28th April. That's when the board also added on in that response their report in response to my directives.
Okay, thanks, Minister. I wanted to get that clarity so we can properly align as to what directive did you give, because earlier we could have spoken about that when before that you could have opted to deal with the dissolution of the board. You would have, or before you could have said to them they must appoint a CEO and failure to all allegations that were perpetrated in the House. I want to ask the Minister, from the allegations made by board members and from all of that factors, how true is it that you give directive on the matter of the CEO and we had an interest on the matter of the CEO? Because I'm asking this secondly for you to tell us, because if there's no documentation, we'll rely on you and the board. But I want to give you an opportunity to tell us what was the discussion precisely and what informed you not to have record keeping in a meeting of a board, because it's a meeting of high level with the minister that might have legal implications, like I was speaking about the legal issues, and I was asking, when are they working, when are they advising?
Yeah. So, firstly, I think I have to emphasize that I did not issue any illegal instruction or directive in that meeting. I think that emphasis is important. But secondly, that the meeting was necessitated, by my engagement with the interim chairperson, and thus the meeting itself. The meeting was not intended in any way to take any statutory decision as expected in terms of the function of the board. The meeting was intended for me to, to listen to the board members on the issues that the interim chairperson, had raised. I had no intention going into that meeting to instruct the board on who they should appoint, for the position of the CEO. I was just concerned around the differences that, that the interim chairperson, had spoken to in relation to the workings of the board.
Can I go back to legal? Because I'm not a legal person. But in this regard, I don't want to go to the merit of the court. Is it permissible that you can have a meeting with the board with high-level discussions and still not have record keeping so that you can prove to the meeting, or what is going to happen in terms of conflict that arises in this particular way, where the board is saying this, the minister is saying this? What becomes your advice in this effect? You would regard for us to find facts, because we must find facts, we must conclude, we must align.
Can I refer you back to the judicial determination, because this matter is before court and this forms part of the arguments about the legality of what has happened for the board to be dissolved and an administrator was appointed.
Okay. Msazana wants to allow him. I'll come. Lonzi as well. I don't know. You want to allow them? Okay.
Ngiyabonga Sihlalo, and thank you for Honorable Law for granting me the opportunity for a follow-up. Minister, for times now, you've been referring to your concern that would have arose from your consultations with the interim chair that you said was overseas at the time of the meeting. And then you said it was a consultative meeting with the board. The board has expressly made it clear that that was an instructive meeting. They didn't interact with yourselves. And there was a person that you said in the meeting is an deputy chair, which they can't confirm because they don't know that person to be a deputy chair. briefed you on their matters without consulting them. So there was a presentation the board members did not know of. So I just want to, it was a follow-up on the first question of Honorable Law on the meeting, the setup of the meeting, before he got to my second question. Maybe if you could just clarify us, why would you have continued with the meeting without the interim chair?
You have asked the question.
And the person, it wasn't consultative as well.
You are asking the question for the second time. Minister?
And I think I've also answered the question, Chairperson.
Yeah.
Thanks, no chair. I'm coming. Let me take Ndadem Gadi. Ndadem Gadi, you would have made a presentation about the SARS data that should have an access to the system. And in my understanding, because at least I'm an HR person, before that you can go to a system, you must get approval. How to is it that the person that you have alleged that is given access to SARS had that particular way? Can you confirm that thing? Because there's a particular way, a law, a policy that prohibits you to get approval in a certain way to get to SARS. I want to confirm that.
Well, thank you, Honorable Law. When this board arrived at NSFAS, because of its policies and data integrity, it had been kicked outside of SARS. And therefore, it would have enabled an environment where those findings of audits of funding dead people would have been done. So our first priority were to pass data policies, including data management and security policy. That then would have been enabled us to be reintegrated back to SARS. So how we would have then measure that integration is the year that is following, which was starting. So the first phase that this board was seized with is to keep the lights on, and you'll see that even in an unaudited annual performance plan, we are sitting at 64, which is above 50. In more than a decade, we've never seen such performance. And of course, we would have come here on the 31st, AG would have received our annual reports and our financial reports. For the first time, we're on course to submit on time. And until then, this disruption of the board. We were integrated back. And of course, we're exploring. We have a lot of conversations with AG around what the minister would have articulated, what other data sources can we use to get closer to making, I would say, correct funding decisions. Thank you.
Thanks. Minister, what propels me as a matter of concern is that if the closeout report of the former administrator is not out, it becomes quite difficult for one to measure as to the progress of NSFAS. And I don't want to quote on what could have been said in Parliament or in the portfolio committee or into that. And then I want to check for you, what measures are you putting in place to ensure that what measures are you putting to ensure that the report is coming out? And then what measures are going to make sure that we don't have these typicals? Because I can't enter into the court issues now. I want to know how will you handle the report, because there's a second opinion of the board about its progress, all of its imperatives. Now we're still waiting for the report to be taken out. What becomes a recourse in this particular way to analyze this particular decision of NSFAS in their progress?
Which report are we referring to?
The closeout report of the administrator. Is it out? Is it received?
No, so as I said, that there's a dispute that and there's been some consistent discussion between the NSFAS, the department, and the former administrator around the closeout report of the NSFAS. And the dispute relates to the former administrator, in this case Nomvalo, believing that his contract was terminated earlier than it was supposed to be. And on the basis of that, has been, has not handed over the report, pending what he believes is judicially or fairly, owed to him by the department. So that's why we don't have, that report. But I think the general performance of the NSFAS in that particular period is something that's of public knowledge.
No, very quickly, Chair. The first one is that I think you had already granted my follow-up earlier on, but I think you said you're going to allow them to respond after Honorable Christians on the unlawful instruction, if they still remember it. But the follow-up to Honorable Law is that I think the legal of the department must not be allowed to run away from this question. Honorable Law is not asking about the merits of the case. Honorable Law is asking, can a formal meeting between a minister and the entity of the department take place without a formal invite, without an agenda, without minutes? Let's put NSFAS aside. Let's say it's a CETA, let's say it's NSF. That's what I understood the question to be. So I don't want legal to run away and say, no, let's wait for the court. We're asking you now as a legal person, can that happen? Can a minister sit a meeting with NSF, no agenda, no formal letter invite, no minutes, exercising public power?
No, DG, this one is for the advocate. It's a general question. So just give a general response. Yeah. No, DG is not going to answer this. Advocate.
Thank you, Mr. Lonzi. I would not advise that anyone, including the minister, do what has happened. It is unfortunate that it has happened, but I would advise against it being repeated. Thank you.
They will answer after lunch. We'll remind them the question. They will answer after lunch. Honorable Law. Thank you, Minister. Lastly, no, I told the police they will come at lunchtime. Don't worry. No. I told them. I told them that. They were saying they want to clamp it. I told them we'll come at lunch. Yeah.
You are not the chairperson.
Honorable Law.
Minister, my last question in all of that, because I would not want to have issues. I want to check what your appointment of an administrator. Did you appoint a fit and a proper person for assessment of Professor Matebula prior for his appointment? And what was the process when you appointed administrator in all of the duplicates of NSFAS? Given the fact that you are from the 3 or 2 administration, what was the criteria that you could have taken to look onto the problems and put the person? Thanks, Chair.
Okay. As I've said, that I believe, and that's why I went ahead with the appointment, that Professor Matebula is a fit and proper person. But also importantly, with regards to the person that we're looking for, was someone with a strong background in finance, but also with the understanding of how the system operates. And I think that based on Professor Matebula's profile, he does meet, the kind of person that an NSFAS administrator should be, and also the looking at the scope of the responsibility that he is to undertake. I think that he is, of course, and maybe just to also include, that he's at the Tshwane University of Technology as the head of the business school. He's also served in various, boards and institutions. So I think all of that cumulatively makes him a fit and proper person.
I'm asking this because earlier when he was appointed, there were allegations that when he was employed at SARS, there was several investigations that took place, the Commission of Inquiry, the Nugget Commission, and then there were final reports on Professor Matebula. Maybe I'm asking that based on the fact, and did you look onto that, because NSFAS is quite complicated, and it's quite having a lot of allegations and stuff. Did you look onto that particular individual to say who had this particular way? And I'm not sure, what were the reports saying, both Nugget and SARS? Did you look onto the reports? Do you have the findings of the report of the particular individual? What did they find about the person? Things?
Yeah. Well, Prof. Matebula did bring to my attention the issues, the report around SARS, And we made inquiries, which included the fact that subsequent to that report, not only was he not, barred from serving in a public or administration office, but he, also actually went on to serve in various boards, both in the private and public sector, and also. I think those include the MDDA and so on and so forth. So I don't think that the reflections made, which also included the fact that he cooperated with that investigation, that ultimately what came out of that report would have disqualified him to serve as NSFAS administrator.
Minister, in paragraph 6, the Nugget Commission criticized Professor Matebula for being willing to investigate SARS employees at the behest of Mr. Moyane without having been given any indication of what they could have done. As per paragraph number 6, in paragraph 12 to 14, the Nugget Commission noted that Professor Matebula signed this support for urgent approval request without properly considering them. It records that he had claimed to have done so in pursuit to threats by Mr. Moyan, which at the ultimate end it has never been reported by Professor Matebula. Those are the allegations that were leveled in the commissions of Nugget. Hence I'm asking, because NSFAS has been accused of HR issues whereby they've been victimization, and NSFAS has financial issues that we could have been dealing with. Hence, I was asking about the COSA report, and NSFAS will not need someone who's been hanging on the commission if we must deal with that. So I was pulling all of this so that we can be able to look onto, if we look onto the thorough individualistic part of the integrity, and the person who should therefore assume if that person must be an administrator. So already me as an individual, I will have a problem with someone who would have such issues in the commission where we need to have NSFAS to be fixed. And where there's a view in society and the view that is divided that says NSFAS was doing good, we could have just added the numbers as per Section 8 of the NSFAS Act and closed the gaps and move in that way. So I'm putting it into these things and I'm asking myself, how will you deal with such? Because there's a report that is quite explicit and telling us what could have happened to the person you've put at the hem of the problem. So at the problems that we're having in terms of our engagement is how we could have appointed put the body to resolution to the courts, and then secondly, the person that you've appointed to look thoroughly to the person, and thirdly, I wanted to know what becomes the procedure and what becomes the criteria to identify the individuals who therefore comes to be administrators. And then, Chair, I'll submit my questions. Thanks.
Okay, I think I did indicate, Professor Matebula's credentials. I also did indicate that I've looked into the issues that you've raised in terms of, of SARS. I think the Commission's report was, if I'm not mistaken, 2018, 2019. I did also look at what Professor Matebula has done since then, the institutions that he's led. I've also looked at whether he has been disbarred from serving in any public office, particularly such a role. And I must also emphasize that, there are rules, regulations that governs the NSFAS, including the NSFAS Act and various other policies. And I think, there would be no hesitation if in any way there is a breach of all those particular And for me, what is important is that, based on his history, particularly in the private and public sector, he is the right person to stabilize the National Student Financial Aid Scheme.
No, thank you very much. It's 1:30. Let's take, DG, you want to say something?
Thank you, Chair. Taking advantage of the fact that we will have a lunch break, I advise that you consult the parliamentary legal colleagues who spoke earlier, because in as much as we have committed to ensuring that we are alert to the matters being sub judice, but when arguments are made, I think we are treading on a thin line. It's not for me to make a call, but I think consulting with them would assist. Thank you, Chair.
Okay, thank you very much, DG. Who will respond after lunch? Let's come back at 2. Let's come back at 2, colleagues.